writ appeal being sans of merit stands dismissed, but in circumstances there shall be no order as to causes.
I agree.
For judgment, WPC 12791 of 2014.
The lecturers in the general college and the lecturers in camps perform different nature of job, whereas no post of lecturer, senior scale and lecturer selection grade are put in place in camps. Such posts are available in respect of general colleges. The promotion to the post of reader requires certain qualifications and prerequisites. The petitioner in the present case is not in possession of PhD qualification. Therefore, neither she can be entitled to the post of lecturer, senior scale and lecturer selection grade, nor could she claim for promotion to the post of reader. In the result, the writ petition is dismissed, but in the circumstances, there shall be no order as to costs.
There's a copy of this that will be communicated to. Oh, okay. I agree.
For judgment, WPC 10498 of 2024.
Finding absence of reasons in the decision of the opposite party director of technical education and training Odisha on the issue of varying with the recommendation of the expert committee members and taking a decision to keep in abeyance the admission of 30 students as recommended in the joint verification report. This court remits the matter to the said authority for a fresh decision. Then in the ultimate, and find the writ petition is disposed of with above direction, but in the circumstances without any order as to costs.
I agree.
Yes, with my Lord's kind permission, last Thursday, my Lord's, I can remember you also have given liberty to remind your Lordship at 10:30 today, my Lords. Because that matter challenging 16(2)C, which is today in the Lordship's board on item number 53, my Lords. Because on the batch of cases, my Lords, because either in some cases counterfiled, copy not served on the petitioner, some cases AD not back, and some cases rejoinder are yet to be received, my Lords. So, my Lords, pleadings to be completed, my Lords, your Lordship have said to fix up a date after vacation, any date of your Lordship's. Because barely 1 week is left. My Lords will kindly fix up any date, my Lords, as your Lordship pleases.
So to be mentioned, tomorrow to be mentioned. Tomorrow to be mentioned for fixing a date of it.
My Lords.
May please, how many matters are there?
My Lords.
How many matters of similar nature?
Let's see the list, I believe about 10 matters, about 10 matters.
Give a slip.
It is already there in the list. Item
All right.
53, my Lords.
Item 68, my lords. Matter was heard for a substantial period.
Sorry, entry want to continue till tomorrow. All these matters, entry want to there.
Heard for a substantial length of time, my lords. We have felt the necessity to file a short additional
On
affidavit.
what?
My lords, this was for admission of students.
In which
My
court?
lords, in that College of Physical Education and Yogi, Ayurvedic College of.
Vedic has not been heard by us.
No, earlier, only a month ago, 4 weeks, 4 or 5 weeks.
So what do you want?
Well, I'm filing an additional affidavit today.
You may file.
Only Lordship may fix up any date. I'll serve a copy of.
Admission matter, that must have become infructuous.
No, this is recognition, admission and recognition. Recognition of the college.
All right, we'll see.
Any date after whenever you're not.
Make a mention after holidays then.
Matters.
Pardon, my lord.
Campus medicine stores. Campus medicine store, your lordship of Thursday, your lordship has heard, and other matters are there.
Give your slips.
Allowed Panda to mention.
These are also med-
Medicine.
Campus medicine.
Campus medicine.
Pardon to make a mention, my lord. Hey, first I mentioned a matter, your lordship is given liberty to mention today, my lord. Item 49. This is a very urgent matter, my lord. It may be taken up tomorrow in the 2 p.m. matter.
What is the urgency?
Urgency is, my lord, the single bench judgment has been stayed by this honorable court, my lord. There is the appointment.
Have you taken consent of the other side?
Yes, my lord. In the yesterday, I have mentioned my lord, trainings, my lord,
Have
single.
you filed any application for vacating the order of stay?
No, the vacation, my lord.
Then there is no urgency. If you have not filed any application for vacating the order of stay, there is no urgency.
Why don't you make a
You file it and make a mention.
I would like to mention, my lord, the custody bail matter, custody bail and the coordinate bench has already passed the order for some of the co-accused persons. And this matter was placed before the regular bench, which directed that the matter should be placed before the lordships to direct the appropriate base to be taken up.
It will be taken up. Such matters, just don't, you're not required to give your slip. All such matters come to me. All right, and I do it on everyday basis. Please don't worry, your matters shall be assigned to someone.
Lord, 1 month, it was last listed prior to 1 month before the Honorable Justice A.K. Manapati.
When was the order passed?
19-3, your lordships. I have
All right.
also quoted. I'm giving it.
Oh, ask the registrar list, deputy registrar, judicial, to meet me with this slip.
Why don't you make a mention, my lord? Item not 25.
Mention my lord, saying campus medicine store matter, my lord.
Give your slip.
D number is there registered.
D number will not be
My
indicated.
lord,
Sorry.
tomorrow for vacation.
Sorry, Will.
directed.
No. Sorry.
My lord,
May I
item-
pardon, my lord? Item number 51 of the 8th supplementary list, which was hearing was closed. Written note of submission, may I? My lord.
Item not 25, my lord. Item not 25. Kindly taken up any other day.
Let the matter be called.
I'll be busy in other courts.
You are busy. I'm very happy that you are busy, but you will have to be here. Or ask some of your friends to be here. We will adjourn.
Item not 12, permitted to.
Withdraw.
We have complied the order, so my.
Contempt. Complied with.
May I make a mention? Item number 50.
Sir, two senior counsel are standing.
I'm sorry.
Please.
I may be pardoned to make mention, my lord. This is a PIL matter, matter relates to non-availability of clean and safe drinking water. This matter, my lord, last occasion was fixed and listed, and your lordship has assigned this matter to the Cuttack PIL bench, my lord. But they are saying that when it relates to entire state, whether the division bench of Cuttack bench will hear or
That bench will hear.
My
Don't
lord.
worry.
oblige, my lord.
You know, I had passed some. The matter had come. In fact, some order has already been passed on administrative side.
On administrative side, your lordship.
Yes, I have already done it. That
This-
matter will go to that bench.
No, that is there, but after
no.
your lordship direction,
Not-
that matter was placed before the Cuttack PIL bench.
Thereafter,
And-
another order was passed
another
authorizing
order-
that.
There is another order. Mr.
Another order has
There
been
is
passed,
another order by the Chief Justice.
my lord.
After that, there is an order passed by the Chief Justice that this matter shall also be heard with that.
Tagged with that.
No, that has been
Mr.
passed,
Mr. Mahanti,
my lord.
my lord has clarified in administrative side to hear that, to place that matter before the,
There is no clarification. There is the Chief Justice's order that this matter shall be placed along with that case. Is it clear now?
My lord, only small submission to be made. As per your lordship's direction, that matter was placed before the Cuttack PIL bench, but that was harsh.
thereafter
different.
another
And-
order of Honorable Chief Justice was passed in that case.
Oblique man.
Yes, sir.
Those day and night medicine saw patterns. Tomorrow is the last day. The number is there.
Number?
Formal order is to be passed.
With your lordship's permission, may I make item number 50 of your lordship's court. Here, the honorable single judge's order has been assailed by the bank. Here, what has happened, the honorable single judge directed to release the funds because,
Who are you?
my lord, I am the respondent in this writ appeal. I was the petitioner before the honorable single judge. It order was in my favor to release bank, direct
Sir,
bank.
how can you mention someone else's appeal
No,
for early hearing?
my lord, I am for the respondent in that.
You are respondent, this is not your appeal.
But my lord, due to that,
Due to dependency, if there is something then that cannot be held.
I have
If
filed a
there is an
vacation of
interim
stay.
order, then
Vacation of stay also I have filed because there is an
Alright.
order of status quo.
that matter will be taken up. Give your IA number.
Well, any day this week suiting to your lordship.
We don't know, but give your. Depend on.
Any day as per
We
your
will see,
lordship.
mister. Give your slip.
Right.
We are not here with your slip. You are making a mention.
No, it is in the list, man. It is in the list,
Which
item number 50.
Item 50. Orders name. We will see, please inform the counsel for the appellant. Who is for the appellant?
My lord, bank lawyer is there, I'll inform.
Please inform.
Any day if your lordship.
We will see. We'll take it.
Press admission item number 2.
Lord, at the outset, I beg excuse for the inconvenience caused to my lords, my lord.
What happened?
That affidavit, I was supposed to file pursuant to my lord's order. But I was waiting for the acknowledgement with regard to filing of rejoinder, which I got it only yesterday night. Today I have filed the affidavit. For your lordship reference, I have kept 2 copies for my lord's reference. Lordship permits me not, can be taken out.
All right. Who is for the other side?
Union of India and state I have
Now I received the copy.
It's a question. Your lordship was dictating the order. Lordship just wanted to know what is the lapsing order, reference of lapsing order. Lapsing order was supposed to.
Oh, there is nothing.
Yes, Lordship.
It will come for orders tomorrow.
Grateful. Item number 3.
Yes, my lord. Last date, honorable court directed to government advocate for instruction.
This matter I talked to the DSW district social welfare officer. Yes, that in elections you are could not take why which time also can grant it so that she can do it.
You can tell him, or you can tell your government that the courts cannot be closed because of the election.
No, not that way, no. In fact,
Alright.
she stated that the petitioner have not appeared before her. In spite of that, I said that you sent that instruction. Because we are duty, lordship can take it up within 2 days also, she can give the instruction. for
All right, I have requested on behalf of the contenders, this matter on Monday, retaining its position.
Yeah.
So the court will consider passing appropriate orders for initiation of contempt proceeding. If in the meanwhile, court's order is not complied with.
Even though no cause of action arose against contempt 1, 2, and 3, that may not be deleted because
One,
is
Except
union-
one, because all opposite parties are not necessary to be made mirrors. Because there was only direction to DSW to consider their case. But all have been made parties.
Home secretary, then chairman.
who has to comply with
SC.
Because the order has to be complied by lordship.
Lordship keep it that I will see.
OP number 8 belongs.
on behalf of opposite party number 8. That will be clear?
Yes, that will clear.
Item number 4.
In both the cases, orders not complied till date. At last occasion, my lord and brother taken time to. Orders have been complied. I've given the copies of the lord's compliance affidavit today, my lordship. Both the cases, orders have been complied.
All right.
I've given a copy to my friend also in
Complied
both
with.
cases, my lord. There was a direction of lordship. And order has also been communicated to him. He has also received the same by way of acknowledgement.
All right. Complied with. Compliance and affidavit has been filed today, from which it appears that the court's order has been. Order violation of which has been alleged in the civil contempt application has been complied with. The contempt proceeding accordingly stands stopped.
Cess admission item number 5.
Yes.
Item 5.
Yes, yes.
It's an appeal. It's a contempt appeal by the appellant is not there, no.
All right, let us.
ପାଞ୍ଚ ଆପଣଙ୍କର 6 ବର୍ଷ if a losses is the order impugned, if a losses page 21 of the sorry, no, sir.
33.
He has paid that the order passed on 13/4/2021 passed by the Honorable Single Judge in contempt number 778 of 2020 be not set aside.
This appeal has been filed under section 19 of the Contempt of Courts Act 1971. A sealing an order dated 28/8/2020 passed in WP passed in CONTC number 778 of 2021. Is that the order? Is the selling which order?
Yes, sir. In his prayer, he has mentioned, if I also look at
Passed
yes, 13/4/2021 778 of 2020.
by the said order. The contempt proceeding initiated contempt proceeding against the respondents, against the respondent's Kardana has been dropped. So stop. While dropping the contempt proceeding, the court noticed, the learned single judge noticed the order dated 28/8/2020 passed in WPC number 19020 of 2020, whereby the contemners were directed to consider, whereby the opposite parties were directed to consider the representation of the petitioner. So stop. The appellant's representation was considered and disposed of. So stop. After having noticed that there was sufficient compliance of the court's order, comma, the learned single judge dropped the contempt proceeding by the impugned order. So stop. Next, since this is an appeal against since the petitioner appellant has filed the present appeal against an order dropping a contempt proceeding, comma, in our considered opinion, the same is not maintainable under section 19 of the Contempt of Courts Act. This appeal is accordingly dismissed. Even otherwise, we do not find any legal infirmity in the order passed by the learned single judge. In the impugned order. Yes. Yes, Mr.
Yeah, let's.
Please come. In fact, just a minute, just a minute. In the last week, some lawyers were complaining that they don't get certified copies in time.
That's correct.
All right. And you have developed a practice of giving the requisites, handing over the requisites to the ushers, the jamadars, and they attach that to file, and then thereafter, and then in every case you make a mention that we should write that urgent copy should be supplied to.
That's correct. Yes, yes.
That is not required for the reason that there is provision for online application.
Correct, correct.
So if you make that online application, you will get certified copy within 1 day or maximum.
Maximum 2 days, yes. That's right.
Maximum 2 days you will get. Secondly,
Section wala creating problem.
sir, I assure you that I am personally monitoring into this.
Grateful.
All
man.
right.
Yes.
So you adopt that practice online and then file your requisitions in appropriate section. I shall monitor to ensure that in no case it takes more than 1 week in supply of the certified copy.
Correct.
All right.
Yes.
So this will happen. So this is why I am suggesting the members of the bar to adopt that online process.
Process and requisites also.
And
Requisites.
yes, online process. If you adopt that, what you are getting free of cost. The copies you are getting free of cost. The online, if you apply online, then why should you do this? And see, corruption in the courts, that is something cannot be tolerated at any cost.
Correct. If you are getting online free of copy, why ever at
You should do that.
I'll
Do
apply.
that, and all those pending this thing, the requisites which are pending. I am personally looking into it, and this system we should
Acquainted to the system. That's correct.
give up the system of handing over requisites to the jamadars.
Yes, correct.
All right.
In some, my lord, in some cases, in the bail matters, suppose order passed, but in fact, order not delivered up to 5 to 6 days, so that they're getting problem
That may be, see, sometimes orders are passed and sometimes the orders are not uploaded.
That's correct.
So till the orders are not uploaded, it means the order has not been signed. There can be many reasons why the order has not been signed.
Maybe, my lord, yeah.
But once the order is signed, and even then you don't get a certified copy, then it's a matter of serious concern.
Correct.
All right. So this is
Rare, okay, so that's not rare.
at times it happens. In fact, sometimes I dictate orders in the courtroom, and it takes time getting the order uploaded. 2 days, 3 days, 4 days. Sometimes
That's correct.
more also. It doesn't happen, but but once that is uploaded and you apply for certified copy, you must get it immediately thereafter. So please tell your members of the bar. I have got circulated the notice which was issued by the High Court for online application and supply of the certified copies. That will go to your association also.
Correct.
And this system, you should decide that this is most informal and archaic system of giving. My lord, take this also. This used to happen in Patna High Court when I had joined in 1990. So that is we should be formal in. So
Well,
this is why.
yes, my lord. I'll
This is why please convey to the members of the bar.
Yes, that's the problem.
If urgent will not be mentioned, then section people are not giving the file because there is
Why are
no.
your chief justice is saying from
Yes,
the court from this chair.
Problem. Yes.
Doesn't mention, doesn't matter.
That is not required to be mentioned even in the order. We should have a system where you get copies on urgent basis.
This is
So
okay.
why is that order?
That's correct, my lord.
All
Obliged, my lord.
So this is why.
Yes, my lord.
Item number 6.
Yes. Yes, your lordship. The last occasion, the 6th of this month, 6th of this month, I made taken time to put for the matter due to non-ability of the office brief, due to shifting of my.
Whether order has been complied with or not.
Your lordship not
Then-
compliant.
All right, let us see the order.
Your lordship, before starting the matter, I have no office brief. That's why I'm,
Then drop it. Run counsel for the petitioner.
your lordship.
It's an appeal, Millers.
It's an appeal.
Yes.
Let us see the order.
No order has been filed.
No order has been filed. All right, where is the file here?
Order filing. Oh, so leave that in anchor, so my lord, if they- I want to- everything else.
No, it's contempt. Huh? All right. Let us see. What is the order? What is your prayer? You have been punished.
Your lordship,
You have been punished.
I am the appellant.
So the only,
Your lordship.
in such cases, appellant can be only such person who has been punished. So you have not been punished. Contempt proceeding has been dropped.
Dropped.
All right. We are dismissing it.
One more time, your lordship.
No more time.
Your lordship, I have no brief to put forth. I have no brief.
We have
Office brief,
everything.
sir.
You cannot say anything.
No, what? I am able to satisfy the court whether it's tenability or not. But it's the completely
Yeah,
question law.
even the,
Sir, what happened?
Mr.
at
Counsel,
the
you have
last
not
occasion-
enclosed the order itself.
Your lordship,
You have not enclosed the
I am
copy
not
of the
able
order
to put
itself.
for, sir, I am not able to put for because I have no file.
So,
So one more chance may be given, with certified copy, I'm going to endeavor to procure within 2 days.
all right.
Sir, within 2 days. I don't want to any waste the valuable time of the.
You have already done that, Mr.
No, sir, last occasion I
You have
endeavor.
already vested. The learned counsel for the appellant states that he does not have a copy of the memo of appeal with him, and therefore the matter should be adjourned. So stop. We decline such a request made by the learned counsel. Stop. This appeal has been filed under section 19(1)(a) of the Contempt of Courts Act 1971 against an order dated (14)9/2022, passed by a learned single judge of this court in CONTC number 5502 of 2022. Stop. Following is the order passed by the learned single judge. Stop. Court Kradanapura. We are of the considered view that this appeal against an order dropping the contempt proceeding is not maintainable under section 19 of the Contempt of Courts Act. So stop. This appeal is accordingly dismissed.
Your Lordship, Your Lordship, Your Lordship,
On 2021, on
6/5/24.
on 6/5/2024, similar prayer was made on behalf of the appellant, and accordingly, the matter was adjourned for today. Today, as it at his request.
Your Lordship, I request before the Honorable Court to give me chance at least hear the matter.
Mr. Counsel, please leave the place where you are standing now. The order has been passed. Call the next case.
Item number 7.
Well, item 7, I am for the appellant, my lord. Well, I need some time to get myself prepared, my lord. Let this matter come after vacation, my lord. April, my lord.
Are you, is there any interim order?
No, my lord.
No,
not.
What is this matter about?
My lord, here the appellant has challenged the order of the learned single judge. Why the learned single judge has allowed the case of the respondent, my lord, and holding that the order passed by the collector is wrong, my lord.
Any objection?
No, my lord.
Yes. Yes.
In fact,
I'm for the written candidate.
may
my lord. I'm for the written candidate. My lord.
Yes, Mr. Acharya, you are also
Reading in this
appearing.
matter, my lord.
my associate, I am there, my lord, my
Okay.
associate is there. I'm sorry, I couldn't reach in time. I
Okay.
was traveling
Adjournment.
for just now. It's 2-year-old matter. It's a well-reasoned order. I am the returned candidate. I am a
No, but he
sarpanch
is
elected.
seeking adjournment. Are you objecting to that?
I think my friend is requesting for time. Let him take.
Yeah. All right, when?
After vacation, my lord.
Yes,
His lordship
after.
pleases.
As
Let
requested.
it come in due course, my lord. There is no urgency. There is no interim order.
No, it will come in due course means?
That is requesting after vacation. Let any date convenient your lordship may put time.
After. It is in due course. No, but we shall give. 1st July. 1st July.
Lord, I was listening to your lordships that provision of online certified copy. It's a very laudable idea. In fact, in Supreme Court also they adopt this practice that once the copy is applied, it is made available.
No,
So
and
it's a
this
very
system,
nice.
this system, I just deprecate it of giving requisites to jamadars of the court and jamadars thoroughly informal kind of thing. So our system cannot accept that.
Right. It's an excellent Lord, idea. I was listening to your lordships views on that. It's very nice.
Let us see,
Because
Mr.
necessarily,
Yes,
it's a very, it would benefit the members of the bar. I
let
was
us
the
see, Mr. Acharya, how does it happen?
diplomats.
Yes, sir.
Item number 8.
Grateful, my lord.
Yes, is that matter, Mr., where the appeal is not maintainable?
Yes, my lord.
Then why should you seek adjournment? If the appeal is not maintainable, then why should you seek adjournment?
My lord, I will bring some judgment. I will
What
show your
will
lordship
The
some judgment, my lord.
227.
Well, as per section 26 of the Odisha Grama Panchayat Act, my lord, for disqualification of a sarpanch, my lord, who has been retained, my lord, it is maintainable. Lordship kindly have a, lordship I will show that day, my lord. That day on July 1st, I will show.
But it's all,
My lord, I have-
it's a
my lord, I have a good
227
Let
process.
him make an
I
attempt,
was
Mr.
going to argue that preliminary objection. It's a 227 process. It's not maintainable. Lord, our own High Court judgment is there on.
All right, let him try, Mr. Acharya. Let him make an attempt.
Obliged, my lord.
Item number 8.
Item 8 on 3/5, I took time before this honorable court. I am only praying, my lord, may kindly be taken up on Thursday. The respondents are coming for a discussion tomorrow. So I only pray Thursday.
This
Maybe
is about what?
this is about my lord.
Yes.
This is
Yes.
about my lord
Whose
regular.
appeal is this?
My lord, is government affiliate.
Or can you argue?
No, no, my lord, I'm saying
Let
what
him-
is my urgency.
Let him,
before the
let
lord.
him say first, we will.
Yes, my lord,
revert.
let them, they are
Yes.
taking time only.
Yes,
My lord, the order regularizing in terms of Patisababan Datta Das case, that is the subject matter of challenge before this honorable court. Now, I have called for a discussion because of the peculiar facts of the case. Last week they couldn't respond. They have assured me to come tomorrow. So I am praying only Thursday.
Thursday, madam.
Maybe it will go in our favor.
We will take up your matter on
My lord,
Thursday.
that's, my lord, only one submission I that finance department has filed it. And they are going to discuss with revenue and
How to
disaster.
know it?
My lord senior told me that revenue disaster.
No, no.
are coming.
Please don't
This
discuss
is the
those.
fight between.
Madam, this
My-
is the court's request
Yes, my.
that don't discuss in the
No,
courtroom
that's I'm not.
such things which you had discussed outside the court.
No, no.
All right,
But two eyes
All
of
right.
class of power between
Oh.
two eyes of substance.
all
So
right.
there, for last
As
1 year, I'm not getting salary.
as-
That's why.
Ms.
As-
Mahapatra,
My lord.
this Patitapavan Dattadas case.
No, this
Honorable
is not
Apex-
Puttamanda's case. This is again
That is a-
sanction vacancy. They are saying all this turns and twists to this case. But I am against sanction vacancy since 2007. And a peon, my lord, in collectorate. Collector is saying he has to deserve to be regularized.
All right, we will hear you on
My lord,
Thursday
my lord,
and the matter shall retain its position.
my lord.
Item 9.
Retaining its position.
May I please, Your Honor? See the last order, 31A. The compliance affidavit has so far not been filed.
What is the order?
In the order, my lord, I have, if you also look at the order, my lord, that is page 22, my lord.
Page 22.
Yes, Annexure 3.
Yes.
My lord, this is a case, my lord, where initially, my lord, interim order.
No, what is the direction?
The initial direction, my lord, if you also look at flag B, I have given details, my lord. Flag B.
May I clarify? Your Lord?
No, just a minute. Where is the order which has been violated?
My lord, the initial order was, the initial order, my lord, on 5/8/2020.
So what was the order?
Order, my lord, as an interim measure, this court direct that no coercive action shall be taken against the petitioner till the next date. Thereafter, my lord, the writ application was dismissed for default, along with a batch of cases. And it was restored subsequently. With the restoration, my lord, the interim order was also restored. Thereafter, my lord, the order has not been complied with. And when the earlier contempt application was taken up, an order was shown on that particular day, 1/8/2023, that it had been complied with. And my lord has disposed of the.
Just a minute. When was the order? When was your contempt petition? This application dismissed for default?
This application dismissed for.
2022. 14/9/2020.
Let me show.
Date and just pointing out, nothing else.
14/9/2022.
22. The writ application was dismissed.
And when was it restored?
It was just.
Sir.
It was restored, my lord, on 14/9/2022.
No, no.
19/5/2023, my lord.
Yes. Then
Thereafter, my lord, that order has not been complied with. I have filed a contempt application. That contempt application was taken up on 1/8/2023. On that particular day, my lord, an order was shown to the court, my lord, which was handed over to the court, and a copy was given to me, my lord, that the order has been complied with. In that order, the additional director, additional endowment commissioner said, because of this decision, because of the earlier order having been complied with, and I have appointing a interim trustee, so this order cannot be complied with. That restoration order is not to be complied with. And on that particular day, my lord, the contempt application was dropped, saying that it has been complied with. Thereafter, the matter was directed to be disturbed for hearing. On 20th, Annexure A/3, kindly see, I have annexed to this application. Page 22, madam. Annexure 3.
Sir, the direction was that no coercive action shall be taken
Yes, ma'am.
against the petitioners.
Yes, ma'am.
So did they take any coercive action?
The course of action, my lord, in our considered opinion, my lord, whatever, my lord, he was, and both of them are interim trustee. So because the writ application was dismissed for default, my lord, they were taken and additional commissioner was given charge.
What is wrong in that?
My lord,
What is wrong in that? Finally, it will be decided, no contempt. Where is the writ petition pending?
writ petition, my lord,
It is come. It is
Yeah.
back to this particular brief, your lordship. It's on board today.
and it was directly listed on 24/9.
Hear that?
Well,
Necessary
Challenging the virus of the
contempt
amendment.
will not. Contempt, we are not satisfied.
Well, only one thing. Can you see Anisha 3?
We will not see contempt. Writ petition is pending. We will decide the writ petition.
But the roster bench is, the assignment is
Assignment is
court number 7. You'll also fix a date, so that it can be.
This is with regard to challenge of the virus of the act, your lordships.
just a minute, let him complete.
Lordships.
So what is the writ petition?
13,000.
13321 of 2020. It was attached to the file, my lord.
That is listed or not?
Yes, your lordships.
So it has been listed, my lord, for reference. But if you lordship put it, my lord, immediately after vacation, my lord, I can argue the matter on merit.
So you are challenging the statutory provision. How do you say that this court should not?
I'm sorry. This is.
Be responsible.
It's challenging the
When do you want? When do you want?
Well, immediately after vacation, madam.
All right. As requested on behalf of the writ petitioner, list this matter on. Yes,
But-
madam, anything?
Well, that's interim order to continue. Whatever interim order, whatever interim order there, let that be continued. Because can you see, madam, Annexure 3 to this content application?
What?
Madam, have seen this and seen the compliance, whatever they have done, madam, on 1/8.
So the interim order, when your writ petition was, see your conduct. You are not seeing your conduct. Should we make certain observations in our order?
No, madam,
That you got an interim order, some interim order,
madam,
and thereafter you got your writ application dismissed.
madam.
And thereafter, one year thereafter, the writ petition was restored. It is your submission that all the interim orders got restored. You are right in your submission. But where is the question of this thing, contempt or interim orders? Is there any requirement
No, your lordships.
of
Can I clarify in just 3 lines, your lordships? The petitioners were appointed as the trustees, your lordships, for a period of 2 years in the year 2016. Before their term could come to an end, they filed a writ petition and took an order, no coercive action. So because of the order, they continued till 2022. The period was for 2 years, they continued for 6 years. In 22, as soon as the writ was dismissed, we immediately took charge of the institution. And then now when they, after about a year, I'm sorry, after about a year, when the writ petition was restored, now they want that they should be given charge of the institution.
Maintain the status quo in the
Lordships. Lordships. There were a batch of matters and all of them have been dismissed. They were heard at length and dismissed. I'll provide the numbers. Lordships. Lordships.
Item number 10.
Then order has not been complied with. In this case, your lordship directed to appoint the petitioner against vacant post within 2 months.
10 and 11,
Last-
both will also call it on Monday. I got instruction, we can comply the order.
11.
11 minor Monday? 11 also Monday.
Item number 13.
Item 13, your lordship, Mr. Acharya had to attend in the last moment a medical emergency. His mother-in-law is in critical condition. He had to rush to the hospital. Your lordship, may kindly. Much obliged. Your Lordship.
Item number 14.
May I please, Your Lordship? The appellant is challenging the order passed by the learned single judge, Your Lordship, wherein the single judge has decided, hold that the two orders passed on the same day is not a fraud. And since the appeal has been, provision is there, so revision is not maintainable in this. So, my lord, so therefore I'm taking Your Lordship that the order which has been set aside by this honorable single judge, that is at page 139. Then I'll come to Your Lordship the facts. I am challenging the impugned order. It is an annexure 1, Your Lordship. No. Single said that since the revision is an special provision for the objective to further interest of the justice, so it is not made out in this case, so therefore set aside. May I take Your Lordship to the order which is been set aside? That will clear Your Lordship. Page 139.
So what is the matter about?
Matter is, Your Lordship, that the land in questions are a government land, Your Lordship, which was the then Secretary of Government of India in 1936 has been given a passed an order wherein and permission has been given to the ex-intermediary that utilize that land for the purpose of the hatto. Hat means the hat. So what happened when at the time of state revolution, that land, particular land, amounting to 84 dismissals, a huge land, has been given by a hatapata by the intermediary to the somebody and sold it. And later, these things are not within the knowledge of the villagers, actually. Some villagers have approached this also. When it came to, thereafter it has been resold to somebody else also. After that, when those people come to occupy the thing, then they come to know, and thereafter they filed an objection before the consultation officer, saying that, showing that agreement in which it has been specifically stated that agreement I have, my lord, it has been annexed to this petition.
Question about the
My lord, my question, there's two orders. Part on the before the consultation officer, Your Lordship, additional consultation, there's two orders passed on the same day. I'll take that orders, Your Lordship. May I kindly see those orders? That is, my lord, those orders are, if Your Lordship will see, those orders I have filed it in my my lord, may kindly turn to page 172. On 22nd of June 1988, an order was passed. The case record is put up today. Revision is allowed. The villagers' revisions are allowed. Order passed in a separate sheet attached. In this, on the same particular date, another order was on the next page, Your Lordship. Petition is present, standing counsel is also present. Parties are not necessarily ready for hearing, so matter is adjourned. What happened, Your Lordship? After these two orders, so I brought to the notice that two orders have been passed. In one order, it is been said that the revision is allowed. In the separate sheet, the order is that revision is dismissed. So two.
That is only now.
So third, Your Lordship, my ground is the fraud visits everything. Since it is in public land, it cannot be given a status of Stitiban.
This aspect now the same day two orders were passed.
That has been said, singular has said that two orders have been passed, but that is, it is not amounts to fraud.
It happens that two orders will make it passed on the same day by High Court also. That happened.
It's happened, my lord, but
By mistake.
by mistake. But is in this order, it is revision is allowed, but two mistakes cannot be taken.
There are two orders.
Two orders in one order, it says that revision is allowed. What I am showing your lordship, that is the order. At-
Answer to that can because of wrong mentioning of case number in one of the cases. And both are signed orders.
No, that is what I am trying to show your lordship. That's the order which is set aside. In that order that the officer has already clearly mentioned how it is a fraud in the court. Then treated it as a clerical error. Then set the matter for
Both
rehearing.
the orders are signed or one order is signed?
Both the orders are signed.
Both the orders are signed.
Both the orders are signed. And so therefore the court said, since both the orders are signed, so therefore it cannot be, and in one order it said the revision is allowed. Then subsequently in the order passed in a separate sheet in which the revision is disallowed. And other order is signed also, then it is also adjourned. So and other thing, your lordship, since it is a public land, it cannot be given citizen status because there is a clear-cut agreement, your lordship, in which it is stated that this intermediary cannot sell it or cannot change the nature of the land also. And those villagers are using that particular land for their hutto, and there are lots of people had their shops also. And because of this order now, these people are suffering because now they are trying to occupy, taking the possession of the land by fencing it.
Didn't with all the aspects.
The government land has been given.
Separate sheet orders are ignored.
Maybe an informative, but not fraud.
That is ignored.
Ignored is
Ignored. Yes.
Maybe there in the file.
It
is not forming part of the order sheet.
No, it is not part. That has been taken out of. We carried our order. Wrong number type. You know.
I understand.
Wrong case number type. Order number type.
But your lordship,
So
in
this is fraud.
no, my lord, see, what happened? Revision is allowed. Revision is allowed. Then it is in the separate sheet order is dismissed.
I understand that.
And moreover, your lordship, the land which has been in the present case, your lordship, it cannot be transferred by any means because it's a government land, your lordship. It was used for the particular purpose because there is an agreement by the then secretary at that point of time, your lordship.
Main ground is review and recall is not permissible after 40 days.
That is the main ground.
That is, but fraud VCS and frauds has can have limitation also.
You are just alleging.
Don't allege
Not
fraud.
demonstrating.
If you allege fraud, then will.
But I am saying, my lord, I don't understand. With government land, I am as a villager, I am protecting, but now government is saying that okay, take it.
No,
It is very easy
My
to
lord,
allege.
fraud on a judicial officer or.
I am not saying that it is the decided by the judicial officer itself.
Burden of proving is very heavy on you to prove that it is fraud.
No, that
Just
is
stating
therefore
fraud
that
will not-
the tribunal, the officer consults of my lord. It's a public land, your lordship. That is the difficulty is that since it's a public land, and government is not taking any chance because now your lordship will kindly see, court said, Nylon Singular said that it's a 15 decimal. It is not a 15 decimal of land because of the satisfaction assigned of this, because 3 petitioners have come to the forward to this court and challenged this order. Other petitioners didn't come, but by virtue of this order, now other people are also taking the benefit of this order because they have not challenged. The court said only 15 decimal of land has been given to the private status. $15 decimal of land. But it is actually, it is 84 dismissal of land has been given.
What happened in that?
My lord,
Come to the first paragraph of your petition.
read petition is challenged by the respondents, your lordship, challenging that order. The order of recalling and as well as the deciding the matter in the favor of the government. My lord, order dated 27 August 2011, wherein the order has been recalled, and then your lordship and fresh hearing was taken on the on the review petition has been taken. Two orders has been challenged. 139, my lord, may kindly turn. It is the respondent's read petition, your lordship. My lord. My lord. Respondent's read petition has been allowed by setting aside those orders.
The final outcome?
Final outcome, my lord, because of this order,
After having the writ application, what will it be like that?
setting aside those two orders passed by the consultation officer. That is at page 139 is the order dated 27th August 2011 and 9th February 2012. My lord. The section 37 euros of the consolidation, Orissa consolidation holding. Power to call for records. The consolidation commissioner may call for and examine the records as any case decided or proceedings taken up by any subordinate authority for the purpose of satisfying section 37 euros. Lordship got it?
Yes, you had filed this review application.
I had filed the review application challenging the assistant commissioner wherein the submission and the prayer of the villagers are rejected on the ground that they couldn't, though it has been given to shown to the agreement has been shown.
Section 37.
My lord.
Who had
The appellants, yes. Against your lordship, there's the consultation commission's order, sir, my lord, that is in the writ petition. Your lordship has at page 105 of my appeal. Also, I have also annexed the entire writ petition. If your lordship will see, that is at page 105.
what is the date?
Date is 24th of February 96, your lordship.
When did you file?
We filed an revision in the year review in 98, Your Lordship.
98?
8
So 24 to 1996 is the order.
order.
There are two orders.
No, that is a single order. Against this order, I file a review before the Consolidation Commissioner, Your Lordship. While the matter was pending in the Consolidation Commissioner, while she was examining, Consolidation Commissioner passed two orders, in which one is said a revision is allowed, then in other seat it has been adjourned. But the separate seat order is revision is dismissed. That order has been challenged. That order has been recalled by a review filed by the villagers, saying that because they were not aware of these orders, because in allowed it has been allowed.
You filed a review application.
Recalling of that order. The recalling of this, the two orders passed in the same date.
What are they?
That is, my lord. In which
So what did we do?
they recall the order. Say,
How many orders?
we said there's a clerical, there's a mistake. There are two orders passed.
Sir, when you went to the commissioner,
My lord.
how many orders were passed by the commissioner?
In the record, it was two orders are passed. That was on 26th of June 98.
26th of
No, sorry, 22nd of June 98.
98. What did you do?
When we brought to the notice of this commissioner, Your Lordship, he called for the records, then saw it and recalled the these orders. This 22nd June to 98 order has been recalled, stating it as an clerical mistake. By order dated 27th.
You file a review act. In review act proceeding, so many orders were passed according to you. Certain orders were passed by the commissioner. Which orders were there?
That is, my lord, I have annexed that is in starting
What
from
is the date?
dates, my lord, 22nd of June 98.
And
On the same day, another order is also passed.
by 26th June 1998.
22nd of June
22nd of June.
98.
Yeah.
Huh.
And 22nd of June,
Revision is allowed,
revision allowed.
my lord.
Revision or review?
Revision. This is 37.
This 7 is review or revision? Revision.
My lord.
Revision. Revision allowed. So what did you find thereafter?
Thereafter, when I brought these the two orders in part, the commissioner called for records, and after finding that there are two orders passed, then it treated it as a clerical mistake and recalled that order in which the revision was dismissed.
Revision was dismissed by which order?
22nd of June 98.
You are saying revision was allowed by.
It is written revision allowed. In the separate seat, the order was there. In the separate seat, it was dismissed. My lord, I am reading that the case record is put up today. Revision is allowed. Order passed in a separate seat. In the separate seat, the order was been dismissed. Separate seat order also I am there.
You said docket note. Docket order is dismissed.
No, allowed. Allowed.
Allowed.
When a separate seat, it is dismissed. And reasoning has been given why this matter blend cannot be given as Titiman status also given by on the subsequent order. When he recalled the order, thereafter he put the matter for re-hearing. The revision petition has been reheard. The opposite party, those who have challenged this order, the respondents, they didn't come forward. So thereafter they proceeded expertise and the matter was decided. Decided in favor of the villagers taking back the land to the government. The direction was all the land has to be the private person's record name has to be deleted and it is to be gone back to the government. This order has been challenged by the respondents of the high single judge.
What has happened? His review petition was allowed. The review petition is at page 88. That was allowed. And that order was challenged by the aggrieved party before the Honorable Single Judge. And the Honorable Single Judge has held that the public has not. But according to the review order of the review,
There was no review, it's a revision.
the revision is there. Again, review was there at the instance of the villager. And
Review
that
of revisional order.
Yes.
And in the review order, the commissioner held that this is a public
No,
property.
he has filed review or recaller.
That your lordship may see page 87. The lordship will the petition is there. Now 136 points.
One, upon one, 135.
137.
130.
As we understand, there was an order passed in exercise of
Power under 37.
by the commissioner.
Yes.
The order sheet shows the revision allowed. The order is revision dismissed.
Yes. That is the discrepancy.
That is the discrepancy. So because of this discrepancy, they filed a review application.
Yes.
Right, exactly.
So that discrepancy, yes,
They filed a review application before the commissioner.
same.
Before the commissioner rejected.
No, Commissioner allowed that.
Allowed that.
Commissioner-
Which is impugned before the Honorable Civil.
Commissioner allowed that.
He directed for rehearing.
Yes. Directed for rehearing, and after rehearing, also thereafter come to a conclusion. This is a government land,
But I
Before,
beg to
before the
submit.
joint commissioner, you were successful.
my lord.
Before
In-
the
But I
joint
beg to
commissioner,
submit
Mike.
that
you were successful.
rejection and allowing that issue, that discrepancy.
It's been
No
challenged.
more survives because that ultimately it ended with the review order, which is in his favor. Which is, and that is impugned in the writ petition. So your lordship is to only, the Honorable Single Judge was called upon to examine whether the review order is justified in accordance with law or not. And the Honorable Court has held that it is liable to be set aside.
Two orders have been challenged.
Review was not maintainable.
Yes. And
No,
and so many decisions have
And
been-
after so,
And then rightly, and then the review is not maintainable, you could not have an entertainment, the absence of any insight of the revision review could not have an entertainment.
That should be, should place before this Honorable Division
There
Bench.
is power of review.
How the
My lord, fraud, if fraud has been alleged, then power is there, my lord. Because, my lord, in one order sheet, it is said that it is allowed, in the separate sheet, it has been said that it is. And the consultation commissioner has clearly said, when he heard the matter, in the revision petition has been heard, had clearly given the finding because it is a government land.
no two reasoned order, only one reasoned order, that is
Yes.
dismissal.
that
It is
discrepancy
only
should not-
the order sheet which reflects some person has written it,
And you could have. done
The
that
authority
on
has
the
signed.
proceeding. That was the
That
discrepancy.
is the
You could have done
that should have been done. He should
That
have filed writ
read
petition again.
petition.
Because why he didn't so, what I find, because he was not a party in that. That is why he filed the review before the same.
And
But at the end of the day, your lordship will see, by that review order, the commissioner has directed that this is a government property. It should be, and he is only relying upon that order by virtue of which this property is directed to be recorded in favor of. the
private party, private people.
And that was altered by the Honorable Single Judge, holding inter alia that it should be recorded in favor of the private. That is the,
No, not single judge held so.
Yes, yes.
no, set aside means,
It is,
so the review petition is dismissed, the original order will stand.
actually, when he was not party to the proceeding, before
Correct.
the joint
Yes,
commissioner.
yes, that is why
So
he resorted to review.
We are the villagers here. We are utilizing their land for
No,
this.
that is not the question. Question is whether you were necessary parties before the, in the
Joint commission.
proceeding before the joint commissioner. No. The state was the necessary party.
But state was the necessary party, but state, since state didn't
So
do it,
state did not come forward.
come forward. So that is why the villagers came. It's a public
And did the
purpose.
state support your case?
My land senior is
There.
support. Because the government land has been unnecessarily given to the private party.
We suffered the order passed by this commissioner and we did not challenge. That is correct. But subsequently, that order has been recalled or reviewed at the instance of the villagers. And that order was challenged before the Honorable High Court. The original order is never challenged by either parties. Either party means only state, because state has only suffered that order, the original order. That order has been recalled, so there was no, my full submission subject to your
No,
lordship.
but you were party in the
Yes,
proceeding
yes.
before the land.
Yes,
commissioner.
Yes.
Yes,
So you are not challenging the order.
no, you have not. Because subsequently it was reviewed or at the instance of the village.
But they have come forward after 14 years. At that relevant point of time, you did not come forward. You slept over your
That is
matter.
there, we cannot.
You slept over. Then how, what is the stake of villagers to be heard?
Only your lordship is to see that whether the review power is there. or
No, there
Is
is
it
not
there?
there.
Is it there?
That is not
No,
there.
there is no specifically.
Specifically, that has to be specifically.
What I
Review-
know. in
Review
Constitutional
power has to be specifically conferred by the legislature. Otherwise, how can you invoke? Is it so much a review power?
But if your lordship will see the review order, which is at Annex 11, the commissioner has dealt with the matter in on merits in a very fantastic manner. That some drama has been played by the.
No, that we cannot do.
No, but only for the purpose of the fraudulent Hatkota has been produced by the,
That history we cannot go into.
only on the point of law, if your lordship will see then whether the review power is, and that has been discussed by the Honorable Single.
Absolutely correct. I thought they were affected parties.
Monday, order tomorrow. We will dictate in the courtroom tomorrow.
My. Lord, the present appellant filed the writ appeal before the Honorable Court challenging the order 7th February 24th passed by this Honorable Judge. The
Where is
respondent-
the order? Which order you are challenging?
Annex 2. My lord.
Annexure 2. Are you sure? Page
Page 18.
18,
18, 1-8.
1-8. Which item is this?
Last page of the writ appeal.
7/2/2024 order he is challenging.
Yes, 7-2.
WA 352.
352.
Yes.
Page 18, 1/8.
So we should dismiss this writ petition with cost. This writ appeal. You filed a writ petition for a direction for disposal of your representation.
I have already given 2 times representation. Annexure.
There in the representation is to cancel the record of right, which could not have been done by the authority. Because
Record
there
of
is a
right
pro-
of another person,
Yes, that is the opposite party number, opposite party
5.
5. But this is a legal procedure under the Survey and Settlement Act. A representation cannot suffice.
This appeal deserves to be dismissed with cost.
My lord.
You are unnecessarily troubling your client.
My lord, the rationale number 5, Percy will occupy the government land.
Maybe
Is some gochara.
the
And that is inconvenient to the
present writ appeal has been filed assigning an order passed by a learned single judge of this court dated 7/2/2023 in WPC number 1851 of 2023. Stop. The said writ petition was filed for disposal of the petitioner's representation, which was there as an Annexure 4 to the writ application. Stop. Learned single judge noticed that by way of representation, the appellant sought to, the appellant had made a prayer for cancellation of record of rights issued in favor of the opposite party number 5 therein. Stop. Next. Learned single judge has, in our opinion, rightly dismissed the writ petition after having noticed that the appellant was unable to satisfy about the reason to cancel the ROR. Stop. The present intra-court appeal is devoid of merit and wholly misconceived. Stop. This appeal is accordingly dismissed. 16. Yes, may I please. Yes, order.
The input order is at page 175.
Stated.
But 175. The date is
Here.
24/1/2024.
Yes, it's there. Yes.
Well, relevant portion I am reading, my lord. Lengthy order, my lord.
So what is the dispute about?
Issue regarding that retrospective promotion on the basis of an repealed rule. A rule has been repealed. The entire case before the single judge. He claims a retrospective promotion in accordance with 1972 rules. That 1972 rules were repealed in 1993. He approached the tribunal in 2014, and after disposal of that case, he again approached this honorable court in 2022. Our case is that since that rule is repealed, no right accrues in his favor.
No, when he thought he claimed his promotion with effect from which date?
By 89.
Effect from 89.
My lord.
He could claim because the rule was not repealed then.
The rule repealed in 1993.
Yes.
He got promotion in 2005.
Yes.
In accordance with 1993 rule.
Yes.
He approached the tribunal in 2014.
Yes.
Once that rule is repealed and more very important, he has not challenged the promotion granted him in 2005. He accepted it, worked in the promotional post. After 9 years, he came and approached to give me promotion in accordance with 1972 rules.
So apart from delay,
yes.
Apart from delay, what point do you have?
Yes, I have a point. That
delay is one part. Second part, one cannot claim a benefit under a rule which is not in force.
No, he is claiming a benefit which accrued to him on a date when the rule was in force.
Yes. And that rule was in, your lordship, that your lordship has seen that judgment of that Anup Senapati. In that case, that has been clearly.
Anup Senapati is different.
My lord, that is the only that one cannot take the advantage of a repealed rule.
No. The repeal rule one can take advantage of if he was entitled to some right had accrued
Yes,
under the
then
rule.
even if that rule is followed, even if that rule is 72 rule is followed, no right is accrued in his favor. Yes. Why I am saying that the concept of 3 years, if your lordship will see that rule, it will be clear, my lord. May I say, what is that rule? If this is the book, my lord. Perhaps that book, that rule is not there.
72 rules are not there.
No, in that book,
It is not there.
it is not there. Perhaps in this book, that is in the old book.
Odisha Subordinate Education Service.
Yes, Odisha Subordinate Education General Branch Rules 1972.
General branch rules.
93 rule is there.
72 rules are not there.
Yes.
992.
Hello, your lordship. This is
Madam.
Your lordship, see rule 10A.
This is 10A doesn't talk of promotion.
That is the selection. He is claiming that promotion in accordance with 10A. And your lordship is very interesting part in that. In order to be eligible for recruitment selection, a candidate must satisfy the following, namely, he must have served in the lower subordinate education service for at least continuous period of 3 years. What he means to say, because whenever I complete 3 years, I will get promotion. That is his case. This is the eligibility criteria. That does not mean whenever he completes 3 years, he will get promotion.
So when did he complete 3 years?
In 89. That is a very short point.
Yes.
Madam, can you see Rule 10B? The next, that has been dealt by the honorable single judge. Rule 10B. The definition can say 10B 2.
You are appearing?
Ma'am.
Then please sit. We'll call.
Ma'am.
Yes. Yes, we have understood. This is your submission.
This is
your submission that is the minimum.
Yes,
period
that
for
is
which
the
a person
eligibility
must have
criteria.
worked.
Yes, madam. Whenever one completes 3 years, then he became eligible for promotion by selection or promotion. Because in 93 that is promotion, in 72 that is selection. He became eligible. It is not his case either before the tribunal nor before the honorable single judge that any of his junior has been promoted. His case is that as similar orders have been passed in other cases, so I may be extended the same benefit.
All right. Yes.
That is his case, my
And
lord.
what is 10B? Let us see.
10B, my lord. 10B, the selection committee constituted under Rule 15 shall select candidates eligible for recruitment by selection. The committee shall meet once in a year, ordinarily during the first week of April, and prepare list of eligible for appointment by selection under Rule 10A. And it does not mean that he will get promotion.
All right. Please.
Yes, my lord. Your lordship may see, the honorable single judge has relied upon certain orders passed in tribunal and the benefit has been granted to them. But Before that, I will bring my lord's notice. Earlier, he has approached the state administrative tribunal. Your lordship, that is the order at page 60. In that case, tribunal directed to consider his case for promotion with retrospective effect. That was challenged before my lords. That was challenged before my lords at page 72. Your lordship disposed of the writ petition directing to take a fresh decision. In accordance with my lord's direction, the government took a fresh decision at page 77, saying that he cannot be granted retrospective promotion. If he will be granted retrospective promotion, the persons who are appointed, who are promoted in between, their interseniority will be disturbed, and no junior has been promoted in the meantime. And he has got promotion in 2005, and he had not challenged his promotion in 2005. So that was rejected. After that rejection, he filed a contempt petition. And in that writ, those who are to be affected by his promotion, if he is given retrospective promotion, they also filed some writ petitions, and a review petition was filed in that case. He filed that contempt petition. Your lordship passed that contempt petition. Your lordship may see my page 93. May lordship got it, page 93.
Just.
It starts from page 92, my lord.
92.
My lord, your lordship may see page 92. Krishna Chandra Pandya, the respondent here, my lord.
Page 92 is some order.
It's order passed in contempt petition, my lord.
Page paragraph.
Yes, COTC number 1097 of 2018. Your lordship got it.
Page 92 is part of. We are just coming back. Very good. Yes.
The contempt was filed by this respondent. Your lordship may see
92 is
A
part of an SC.
annexure. Lordship, that a first consolidated court title, my lord, then contempt COTC 1097 of 2018.
Oh, sorry. Just a minute.
Lordship got it.
Now I'll get it.
This contempt was because before that, my lord, may I bring to my lord's notice that your lordship may see page 77.
92, we are there.
My lord.
Yes, 92.
Before that, your lordship, for the moment, your lordship may see page 77. Why I am showing, my lord?
Page 77.
My lord. When in compliance to the order passed by this honorable court, a speaking order was passed at page 77. Your lordship may see that 18/9/2017.
Yes.
Thereafter, he filed a contempt petition. That contempt petition that at page 92. And in that contempt petition and in that writ petition, many review petitions were filed, those who are to be affected by the outcome of that writ petition. All the matters were heard together at your lordship may see page 93.
Yes.
Well, I'm reading the last paragraph. Considering the submission of the learned counsel for the parties, this court disposed of all the consueties, writ petitions, review petitions, with an observation that since different original applications, different writ petitions have been filed and different orders have been passed in different dates, and it was not brought to the knowledge of the court regarding the status of the parties and their serial numbers in the gradation list, and moreover, the fact that the government has already implemented the order by giving antecedent promotion to some applicants, if the present case are falling within the purview of those court tribunals orders, in which in such event, the opposite party number 1 shall afford an opportunity of hearing to all the applicants in respective court, contempts, read petitions, review petition, and pass a reasoned order to that effect. However, the entire exercise shall be completed within a period of 3 months from the date of receipt of a copy of this order, without being influenced by the earlier order passed by this court and tribunal. Here, my lord, division bench passed that order without being influenced by the earlier orders passed to pass his reasoned order. My said respondent challenged this order before the Honorable Apex Court.
This order is passed not only in contempt petition.
And
but
review, because
also-
review and read petition, 5 read
All.
petitions, those who are to be affected if he is given retrospective promotion. So they also approach this Honorable Court, and review petitions were filed. All the matters were taken up. And the Honorable Division was said without being influenced by the earlier orders to pass a fresh order. He challenged this order before the Honorable Apex Court, my lord. Let's see page 95, the Honorable Apex Court's order.
Yes.
Let's see page 96.
Yes, we have seen.
Honorable Apex Court also said you passed the order on merit. Thereafter, a reasoned order was passed. LRC can find it from page 110.
Yes.
LRC see, I am drawing my lord's notice only 2-3 paragraphs of that page 122, my lord. LRC.
Yes. Yes.
The last paragraph.
Yes.
That allowing retrospective promotion to both the opposite parties and similarly would unsettle the settled position of teachers in the gradation list of junior SES teachers and senior SES teachers, and thus give right to the serious litigations and disturb the entire cadre of junior SES and senior SES cadre. That allowing retrospective promotion to the applicants and similarly placed person would affect junior SES teachers of taken over high schools who were earlier regularly appointed by the managing committee and merged into the cadre of with effect from 7/6/1994. The date on which the applicant in the way number so-and-so were not regular teachers. Promoting these ad hoc teachers retrospectively from 1986 would be prejudicial to the senior teachers and taken over merged in the cadre after 7/6/1994. This may give so-and-so. This was the last ground because it will unsettle all the settled position. If you want, your lordship know that settled position of law, if one comes for promotion after years, then at the threshold that should not be entertained.
Yes.
And he got the promotion in 2005, and he never challenged that promotion in 2005. He never said in 2005 I should be given promotion from 1989. And in that read petition, he has not said my junior has been promoted. Unless a junior is promoted, if he has the requisite qualification suitable in all respect, he has no right to claim promotion. And promotion is not a matter of right, unless a junior supersedes him.
Yes.
And the Honorable Single Judge, while deciding the matter, has relied upon earlier orders passed by the different tribunals in different times and granted the relief to him. When the Honorable Division Bench has said not being influenced by the order of earlier orders. This is the case, man.
So is this the case of the respondent that because of any order passed by tribunal or the High Court, someone junior to him got promotion.
Yes, my lord, that is not his case. If that I am submitting from the beginning, if that would have been the case, then he has a case. Because if junior cannot supersede him, having he had the requisite qualification and suitable for that post. It is not his case. It is his case only because similarly situated persons have got the promotion, and the entire case, my lord, he has relied upon the first case in that tribunal. Your lordship may see that Nabin Khamari case, the first case. What was the order passed in that case? Your lordship may see page 51. In that case, the tribunal held, as the juniors have been promoted, you give him promotion. It is not his case, Nabin Khamari is junior to him. It is not his case before the tribunal, either before the tribunal or before the honorable single judge. Any junior has been promoted, he has been ignored. Only his case, because of 72 rule or 93 rule, whenever he has completed 3 years, he is eligible for promotion from after completion of 3 years, which is the eligibility criteria.
Yes, that's all.
That's it.
My first submission, my lord, is there are 44 cases or
Come this side.
Huh?
Please come this side.
Sorry.
So you are entitled to promotion with effect from which date?
I am entitled to promotion from 89 because of the
Just a minute.
rule.
You are entitled for promotion with effect from 89. On what basis?
On the basis of rule 10B of the rule of the 74 rule, which speaks that every year the selection committee shall be held every year. That was decided by law tribunal in batch of and one petition that one the direction for
Where
every
is the requirement that every year the
selection
should be
board
held?
shall.
Please read that.
That was it. 10B of the 72
Please
rules.
read, please read.
The committee shall meet once in a year.
See, it's ordinarily what is there.
No,
Please read.
committee shall meet once a year ordinarily during the
Yes. Ordinarily.
Yes.
So that is not mandatory.
That alone tribunal decided that it is mandatory. They should have considered. They should have held
Should have is a different thing.
And that my lord, another aspect, my lord, is that my first submission that you have.
So if you are basing your claim on that ground,
My lord.
that because you had completed 3 years, therefore you should have been granted promotion with you from that date, that cannot be accepted.
That
All right. Now
another case, my lord,
come to another thing.
while the director of the appellant number 2, he gave a report to the government in 2014 that these persons should have been given retrospective promotion.
So should have been
That on basis,
We,
my lord,
Mr. Counsel, we in the High Court determine your rights.
my lord.
So if we issue any direction, we do that only after coming to a conclusion that you had a right, which is to be enforced.
That is, my lord.
So what is the right?
Right, my lord, under rule 10B, and that benefit has been, and benefit.
Right can accrue to you in 2 circumstances.
My lord.
1, if the rules say strictly, and 2, if someone junior has been given that benefit. These are only 2 circumstances.
Junior not given, the law tribunal decided the issue, and others have been given the benefit. That is when kindly say answer 17. Many persons are given the same benefit, retrospective promotion by government. That is kindly see, my lord. That kindly see. Page pursuant to law tribunal, they have given the benefit. That not this single judge decided that once they given the benefit to others, why not to this person? I rely upon that. Relied upon that, my lord. Arvind Srivastava, as well as 3 decisions of Dismissal court, that once you have extended the benefit, you cannot make discrimination to up to single person. That is my that they are given. Kindly see, my lord, that given after, my lord, page 90.
No, we are again putting the same question.
My lord.
Whether any person junior to you has been given promotion or not.
No, junior not given. Or similar promotion, kindly see page 103. Kindly see one paragraph, page 103. Kindly see. Kindly see page 103. Government itself, announcement 102, pursuant to order of Judicial court.
And why did you not raise your plea in 2005 when promotion was granted?
No, we had representation 2011 to 7. Tribunal passed in similar matter, granting retrospective promotion. Government complied 2011 matter. 2011 government complied the order, granting retrospective Rabindra Kumar Panda.
All right, we will decide.
Thereafter, we approached, we filed representation, and ultimately 2014 government, 2011 filed petition to tribunal. Tribunal approached 2011 matter. Tribunal had to consider the cases.
All right.
And the honorable single judge, relying on all the decisions, kindly elaborate discuss the matter.
We will consider.
Madam?
We will consider those decisions.
My lord. And I have filed my objection at Flag D, enclosing my lord's order in similar matter. Flag D. We have already filed.
For learned AGA for the appellant and learned your
LK Mahanti
for the sole respondent. So is this matter for judgment on June 1st? July 1st.
May I plead notes? Notes in this writ appeal, my lord, the appellant is challenging my lord's single judge order dated 19/3/2024, passed in WPC number 6490 of 2024.
Just a minute, where is the order?
Lord, that is as Annexure 3, page 49.
Yes.
My lord, in order to justify the grounds taken in this intra-court appeal, my lord, may be permitted to place an earlier writ application. In an earlier writ application which has given rise to the subsequent writ application.
No, you are challenging this order.
Yes.
Page 51.
My lord.
Page 51.
Yes, my lord. My lord, the writ application that this writ application number 6490 of 2024 was pursuant to an order dated 15/2/2024 of the Honorable Court in WPC number 2433 of 2023, which was directed against a posse illegal order dated 16/12/2023.
Just a minute.
Yes.
So are we correct that you are challenging this order 19/3/2024?
Yes, my lord.
So what is the illegality in that order?
My lord, page 52 is relevant, my lord.
Yes.
My lord, only on the sole basis of submission made by the State Council, this order has been passed. And it is paragraph 4.1, Mr. Mishra Leonard ASG submits that earlier this petitioner had moved that the court in WPC number 2433 of 2024, which was disposed of on 15th February 2024. He therefore submits that the petitioner is in habit of moving this court again and again in view of the fact that the dispute case is not ready for final disposal. The prayer made in this writ application cannot be granted. Taking into submission made by the learned counsel for the parties, this court finds that the dispute case is not ready for final disposal, as well as the petition filed by the petitioner defendant number 3 on 2nd March 2024 are pending for consideration. It is, however, submitted by learned counsel for the petitioner that the additional register is not proceeding with the matter and adjourning it to different dates. In view of the above, this court disposes of the writ petition with an observation that since the dispute case is not ready for hearing, no direction for early disposal of the same can be issued. However, the additional register cooperative societies shall proceed with the matter without granting any unnecessary long adjournments in the matter. The parties, including the petitioner, are directed to cooperate with the additional register cooperative societies for proceeding with the dispute case. In order to justify my grounds of this appeal before my lords, I have also filed an additional affidavit on 9 May 2024.
in order to bring all these things clear, my lord, may kindly have a glance to the additional affidavit. That is Annexure 4, page 6. The learned advocate for the plaintiff and defendant number 3 are present. The learned advocate for the defendant number 3 filed a petition on.
What do you want? What is the dispute?
My lord, in spite of my lord's order, earlier writ application in dated 15/2/2024, the said authority is not at all prepared to carry out my lord's order.
Which authority?
My lord, the respondent number 2, my lord.
Who is responding?
Additional Register of Cooperative Society Scheme and Legal.
What is he required to do?
My lord,
What is he? Which kind of proceeding is pending before him?
for the dispute case number 172 of
Under which provision
2004.
of law?
Lord?
Under which provision?
Yes, the dispute case was filed on section 68 of Orissa Cooperative Societies Act 1962.
This dispute case is pending before the concerned officer since now and it is not being disposed of and it is reviewed. In the last order, your lordship has directed me to obtain just information regarding the status of the case. I have obtained the information. He is now proceeding the case with short dates and he is also there, both parties are there before this. And the last date was 10 May 2024. But I pray before your lordship may direct your authority to dispose of their case within 2-3 months and in accordance with law. That will suffice his grievance.
My lord, the entire, in order to justify the grounds in this appeal before lordships.
Mr. Counsel, we can dispose of the writ
Yes.
appeal
Ma'am.
with this modification only
Yes.
that the appeal, the
It's dispute case, dispute case
shall be disposed
of
of.
2004, my lord.
Now it is proceeding.
It
You
is
also
proceeding and with many series of casual orders. And in order to justify that, I have also placed the entire
We
certified
cannot
copies.
monitor that.
I don't say.
We should not monitor the proceedings
Against
before
that
the
order,
original registrar.
tribunal is
Madam-
there. So many forums are there. Now in writ appeal, you cannot say that this order.
So we shall restrain you from filing any writ petition till the matter is decided one,
Yes.
and you can prefer appeal
Yes.
only, not, you shall not
Yes.
come to the High Court.
Madam,
against that.
madam, yes, yes.
That is
Start-
statutory
Yes,
right.
yes.
Necessarily you are troubling your client by
My lord, I am appearing on behalf of respondent number 4, bank.
ensure that that is expedited.
Both of them will cooperate.
Yes, yes.
A dispute case number 172 of 2 is pending before the learned additional registrar cooperative societies,
Scheme and legal.
bracketed legal and scheme, comma, Bhubaneswar. Full stop. The petitioner, the appellant filed a writ petition, giving rise to WPC number 6490 of 2024, seeking a direction for early disposal of the said dispute case. Full stop. The writ petition has been disposed of by an order dated 19/3/2024 by a learned single judge of this court with an observation that the parties, including the appellant, should cooperate with the proceeding before the additional registrar cooperative societies. In this said case, the learned single judge declined to issue any direction for early disposal of the dispute case in view of the fact that the said dispute case was not ready for hearing. So stop. while disposing of the writ petition, learned single judge has also noticed the habit of the petitioner, appellant, approaching this court time and again for the same purpose, of disposal of said dispute case. Stop. Next. Mr. Mohanty, learned additional government advocate, has informed this court that the additional registrar is proceeding with the matter now,
And short dates are
and
even the substitutes.
wherein the parties are, including the appellant, are appearing.
Yes.
Stop. There is an application for substitution pending.
Yes.
Stop. He has also informed this court that the dispute case is likely to be disposed of within 3 months.
There is a trial procedure, so both parties will lead evidence. It may take some time.
It is 4 months.
4 months.
4 months.
All right.
4 months. Stop. Next. Taking into account the submission advanced on behalf of, advanced by Mr. Mohanty, we dispose of the present writ appeal without interfering with the impugned order passed by the learned single judge, with the only modification that let dispute case be number so and so be concluded, be decided within 4 months from today. Full stop. It is also made clear that if the additional registrar, for genuine and bona fide reasons, not able to dispose of the said dispute case within 4 months, he may seek extension by filing an application in the present matter. Extension of time. Yes. So it appeal stands disposed of.
Deeply obliged. Branch manager appeared
Yes.
on 10/5.
Oh, today filed Bhakalagna. My name may be.
No, your branch manager was directed to appear in person there on 10/5. After 10/5, what?
Appeared before the
On
learned
that
court
date,
below.
On that date, substitution.
No, substitute. Another petition filed by the appellant.
2 applications are also pending there.
Actually, he is also filing numerous applications.
Number of application. Appellant
My
filing
lord, 2
number
of
of
the
application.
applications are also pending, my lord.
Start the trial, then only the case can be disposed.
Yes.
Because both parties have to let oral
My lord,
evidence.
upon disposal of all pending applications.
File for 10, 12 more applications.
Yes.
File any
Yeah.
further application.
Yes.
Because you are going against your own.
Restraint to the appellant to not to file.
No, that cannot be. Can be restrained.
My lord, my name may be
Then
recorded.
it would have been better if
Yes,
6
no
months
problem.
time with them.
6 months, your lordship may 6 months. But I got it.
4 months.
4 months.
Item 18.
Deeply obliged.
So both.
Both parties will lead evidence.
That time we will take.
4 months we have given. 4 months.
Yes.
And
With
if
the
you
liberty
can't,
to.
That liberty is there for it.
yes.
May I please, my lord?
Item number 18.
May I please, my lord? In this case, your lordship had directed the government to file an affidavit regarding the status of preparing a common cadre in accordance with the direction of this honorable court in the case of Premalata Rao. And they had filed an affidavit, a copy of which has been shopped on me. With your lordship's permission, I would just
submit a note which I'll place for your lordship's kind consideration. My lord, this concept of common cadre has to be taken with a pinch of salt, your lordship, because this is actually too much of ado for actually nothing. In fact, there is a common cadre which is existing, as has been ratified and given stamp by this honorable court, your lordship, in a case that I will cite and I'll provide for your lordship's kind consideration. But coming to the conduct of the opposite parties in creating a common cadre, as was directed by this honorable court, in timeline, your lordship would kindly mark that they
Let
were.
us see the order first. Order of this court.
My lord.
Order of this court.
Order of this court at Annexure 7, your lordship. Annexure 7 and the relevant part as page 90, 87 to 90, your lordship.
Yes.
My lord, the issue that was involved in this case is that whether there is a common cadre or not, whether the principles that are applicable in order to appoint a principal of a college should be followed or not. Your lordship, so far as the common cadre question is concerned, they haven't followed the timeline, that is different. And your lordship, they have admitted self. Your lordship may kindly come to their affidavit, page number 6, your lordship. Under Roman 5, under paragraph 6, page number 6 of their paragraph, they have said that there are 5 categories of teachers and they need to be put into the common cadre. In fact, what is happening here is there is a common cadre by their own order, and that has been stamped by this honorable court, that anybody who enters into the service of an aided college with full salary, full GIA, is automatically part of a common cadre. That has been held in a judgment of this honorable court. With the lordship's
permission. Prayer in the writ proceeding?
My lord, the prayer was to quash the appointment order of opposite party number 5, who belongs to, who was initially appointed to a school, your lordship, a junior lecturer, and he has been appointed as the principal of an autonomous college, which is a degree college. Therefore, their own rule, and in fact, in these proceedings that they have carried out in compliance to this honorable court's order towards preparing a common cadre, at least they make this division clear, that there are 2 categories of lecturers, one are junior lecturers and one are degree college lecturers. So that division is clear. Apart from that division, there are a lot of problems they are trying to grapple with in order to prepare a gradation list out of the common cadre.
No, where is the post of lecturer?
My lord.
Lecturer post is under which provision?
My lord, under Education Act, your lordship, the teachers in the government aided colleges.
Whether that post is recognized by the UGC?
UGC, the state is recognizing it. Yes, UGC also recognizes the post of lecturers in.
So all these are degree colleges.
My lord, there are degree in this state. The education department is can be best described as a labyrinth of illegalities. Your lordship, they have said that there are 5 categories of teachers appointed. I have placed before your lordship, there are at least 10 categories of teachers appointed. There are +2 colleges, there are standalone +2 colleges, there are composite colleges, there are degree colleges. The categories vary widely, your lordship, and the ways they have been appointed are 10 I have identified.
All right.
So
what is your case?
My case is that among these 10 and of all these categories that are existing.
No, you are concerned with only one post of principal.
The principal of the degree college where I have been working, and I am initially appointed against a degree college. And they have appointed somebody who comes from a school, who comes from a junior college, that is a school. And the rule your lordship had also earlier held that a person coming from junior college cannot be appointed as the principal of a degree college.
So what is junior college?
Junior college is a +2 college where 11th and 12th are taught. In that college, the opposite party number 5 was appointed, and he has been appointed as the principal of an autonomous college, degree college, which according to their framed rule is not permissible. I would like to draw your lordship's kind attention to their own framed rule, your lordship. That's at page number
page number 33, where they say that a reader belongs to junior lecturer and thus not eligible for appointment as principal to degree college. This is a clear principle that is there.
Reader, what is reader?
A reader is the highest, the third stage after being appointed as a lecturer. One becomes senior lecturer, then becomes reader. So
That system is going on here.
that is going on there.
That has been done away with, I think, by the.
That's basically that what your lordship is hinting at is for the university. They have made three categories there. The one is assistant professor, then associate professor, then professor. The concept of senior lecturer and reader have been merged into this category of associate professor. That's in the university level. That has not been adopted for these colleges, particularly for non-aided colleges. They don't join with any designation except lecturer. Then they get to the position of reader, senior lecturer, then reader. That is actually they're calling it in a different name. Lecturer senior scale, lecturer state scale. So they haven't adopted the nomenclature that is approved by UGC, but they're going in this way that reader is, your lordship can visualize that reader is a post comparable with associate professor. So that is the position. Here the writ petition was filed that since it is a.
So who is opposite party number 5?
Opposite party number 5.
Someone is appearing.
Yes, madam. I pray, madam, just now I received the affidavit filed by the state government, madam. I have not received any appeal memo filed by my lord and friend, madam.
I just gave
him.
Yes.
I just gave it.
Let a copy. I will file my reply, my lord.
I just gave it.
It's absolutely wrong, my lord, that I have never been appointed as a junior lecturer, and the concept of junior lecturer came much after the appointment of the petitioner, my lord. Now, all these things have been decided by the dividend bench on the basis of which Premlata Rao's case was disposed of. That was not being challenged. That is the settled position of law on the basis of which.
So there is no requirement of filing your reply. We can.
My lord, yes, I will brought into the record the allegation made by my lord and friend, my lord. I have filed my reply in the WPC, my lord.
All right.
I want to file the appeal memo. I have not seen what
Appeal
are the
memo,
grounds.
please
I have
give
given just not appeal memo. I have given a response. I just give you.
No, please give him. You
Appeal
have
memo.
filed an appeal.
My lord.
What are
Which
the
is
grounds?
against him.
My lord.
Yes,
You have a duty to
My-
serve upon. Let a copy of the memo of appeal be served by learned counsel for the appeal upon
Amitabh Das,
Mr. Avitav Das, learned counsel,
respondent number.
who
OP number 5.
represents OP number, who accepts notice on behalf of OP number 5. Respond number 5. So stop. List this matter on when? After holidays.
A date.
Date will be there.
My lord. Oblige.
Item 19. May I please your lordship? The order dated 24/4 of 2024 passed by Honorable Single Judge is assailed, my lord. Fact of the case is, my lord, the departmental proceeding initiated against the petitioner in the year 2005 and it was completed in the year 2007, inflicting punishment of removal from service. Thereafter, appeal was filed. In the appeal, the order was punishment confirmed. Thereafter, writ petition was preferred before this honorable court, and this honorable court under Annexure 1 disposed of the writ petition, directing the authority provide the document and then giving opportunity of a hearing and receiving the reply. Conclude the proceeding within 6 months. The authority did not provide the documents. Thereafter, the petitioner filed another writ petition before this honorable court. That is under Annexure 2, page 21. Again, this honorable directed the authority to provide the document first, then proceeded with the departmental proceeding. Since then, they did not provide the documents. Therefore, I preferred the writ petition seeking relief for quashing of the departmental proceeding on the ground of a delay.
That cannot be done.
That was not done. The Honorable Single Judge again directed conclude the proceeding within 3 months, though I have been retired from service on 30th April 2024. That is my grievance, my lord.
So under the bank rules, you can even be dismissed.
My lord.
Under the regulations of the bank,
Yes, my lord.
even after your retirement, order of dismissal can be passed. This is possibly the provision.
Yes, my lord.
Under their regulation.
Yes, my lord.
So that there is nothing wrong in the order.
So they are not providing the documents, but they are not doing anything.
Alright.
Since 2007 and the order of the Sonal Court 2010, within 6 months is reckoned till 2024, my lord.
So did you approach the?
I have approached many times, your lordships. I have seen the order
Direction.
passed of the writ petition of 2011. Because of non-supply of the documents, I compelled myself to approach the Sonal Court. Again, the Sonal Court in the year 2011 directed the authority, provide the document fast.
We do understand, Mr. Counsel, so many things. However, the order does not require any interference. Mainly on the ground that a departmental proceeding initiated against the appellant, who was an employee of UCO Bank, mainly on the ground. Mainly on the ground. Merely on the ground of delay in conclusion of departmental proceeding against the appellant initiated in 2005, the appellant filed a writ petition giving rise to WPC number 655 of 2012 for quashing of the entire disciplinary proceeding. Stop. The appellant was an employee of UCO Bank, and it has been stated by learned counsel for the appellant that after attaining the age of superannuation, he retired in
30th April 2024.
30th of April 2024. Stop. A learned single judge disposed of the said writ petition by an order dated 24/4/2024 with a direction to the UCO Bank and its officials, concerned officials, to conclude the departmental proceeding within a period of 3 months from the presentation of the order. Stop. The said order dated 24/4/2024 passed by the learned single judge has been challenged in the present intra-court appeal. Stop. Next. Learned counsel appearing on behalf of the appellant has submitted that despite repeated orders, despite repeated requests, the petitioner, the appellant is not being supplied the documents which are relevant for just disposal of the departmental proceeding. Stop. Next. Learned single judge in the said impugned order has observed that any document, relevant to the departmental proceeding, may be supplied to the petitioner within 15 days from the date of the said order dated 24/4/2024. Have you filed any application? Did you file any application?
I have approached before this honor could not gone there.
It is an admitted position that the appellant did not comply with, carry out the order dated 24/4/2024 for by approaching the appropriate authority for supply of the documents. Full stop. It is noteworthy that by the said order of the learned single judge, the petitioner was required to approach the opposite party / UFO bank physically to collect the document and copies with further observation that opposite party that the respondent / bank shall keep a record of signature of the present of the appellant when the documents are handed over to him. Full stop. Next. We do not approve of the appellant's conduct of filing the present appeal against the order passed by the learned single judge, whereby he was directed to collect the documents which according to him were relevant for just conclusion of the departmental proceeding. Full stop. By making delay in conclusion of departmental proceeding itself cannot be a ground for quashing of the entire proceeding. Full stop. Next. In such view of the matter, while dismissing the present writ appeal, we observe that it shall be open to the petitioner to the appellant to approach the inquiring officer for supply of the documents which, according to him, are required for, are relevant for the said proceeding. First off, it will be open for the inquiring officer to decline supply of the documents if the same are not found to be relevant for the said proceeding. By an order. Stop. If the such documents which are relevant, it goes without saying that such documents which are relevant and upon which the department intends to rely to prove the charge against the appellant must be supplied to him within a reasonable time. First off. Next, we further observe that if the appellant does not cooperate in the departmental proceeding, the concerned authority shall be at liberty to pass appropriate orders in accordance with law in the departmental proceeding. This appeal stands disposed of with the aforesaid observation.
Item number 20.
Item number 20, my lords, I'm on behalf of Mr. Omsuru seeking an adjournment because he went to his constituency for casting of his vote.
There is nothing in this. The nursing matter is over.
Lordship, on the last date, my lords had put a question to me
on whether retrospective affiliation is permissible under the statute or not. Now, the relevant provisions of the statute and the first statute, which is a delegated regulation, I have those provisions. They allow for provisional application. However, it does not expressly allow for retrospective.
No, that is impermissible. That cannot be.
Well, then I also have that Bihar High Court judgment, which you lots mentioned, referred to. I have copies of that as well.
What is that, Thakur or something?
Well, it is Vijay Shankar Rai versus State of Bihar. It is the first judgment dated 1st June 2023. It holds that the last paragraph, I shall just quote my words. I come to the conclusion that affiliation recognition to college cannot be granted with retrospective effect for the session 2020 to 21. And further, no direction can be issued to the university to hold special examinations of the student of BA, BSc, BCom.
Oh, that was in a different context. All right. So tomorrow?
My lord, on 15th May,
No.
right?
Tomorrow.
Obliged. I'll-
कोई judgment आ रहा है ना? कोई judgment आएगा. बस.
Item 21.
Let's item 21. We will file the English translated copy of ODI annexure minus annexure 2.
What is this about?
Because this is about, my lord, we have challenged here the order of passed by the Tahsildar Daspala, my lords, opposite pattern now 3. But that annexure 5, my lords.
So this is a second writ petition.
My lords.
And what happened to first?
My lords, that was in form of PIL, my lords, that was disposed of. My lords, directing the opposite partner now 3 to consider the representation of this.
It's
So
at page
representation
26,
considered.
ma'am. Page 26, the last order is there, ma'am. Twenty-four and 26, my lord, two orders. They filed a contempt also.
So now the order has been passed.
Yes, now the order has been passed. That is at page 27, annexure 5.
Yes. So what do you want?
Let's, we'll file the English translated copy of annexure 2, my lords.
No, which is the order which has been passed?
My lords, that is at annexure 5, page number 27.
Yes, this is there. What is there in the order which is illegal?
My lords, may see. My lords, sixth line from the top, my lords. My lords, herein the Tahsildar has held that the land is not reserved for any specific purpose. My lords, the land is reserved.
So who will decide it? High Court. Because for that we will have to go there. To see whether
What is that building?
That is a community center, my lords.
Is that not on the pond, on the embankment? These opposite party 5 and 7 are trying to construct a building.
And both the
that is-
plots are, my lords, reserved for the Panchayat.
He says it is not there for Panchayat.
Reserved for resources.
The thing, pond.
No construction on the pond as such.
The can dispose it off. The petitioner or petitioners?
Petitioners, my
The petitioners had earlier approached this court by filing a public interest litigation giving rise to WPC number 5076
My
of
lords.
Yes, yes.
2023, alleging construction encroachment and construction over a government land in the nature of pond.
Embankment, not on the pond. It is
The nature of-
basically on the embankment
And
Embankment of a pond.
of the
My
pond.
embankment of a pond by response number 4 to 6, opposite parties number 4 to
Yes.
6.
4 to 6
Yes.
minutes.
By opposite parties number 4 to 6. First off, the said writ petition was disposed of by this court by an order dated
2023.
28 to 2023, asking the Tahsildar of which place?
My lords,
Daspala.
Daspala.
Yeah, Raspala.
Thus,
My lords,
Daspala.
Daspala.
Daspala to dispose of petitioner's representation after giving the petitioners and opposite parties number 5, 4 to 6, 4 to 6,
4 to 6 minutes.
comma, an opportunity of hearing. Full stop. Alleging non-compliance of the order, the petitioners had filed a contempt application giving rise to 5693 of 2023, which came to be disposed of by an order dated 17/8/2023, requiring the Tahsildar to comply with the order within 3 months from the date of communication of certified copy of the order of the said order dated 17/8/2023. Stop. It appears
It was complied before that.
that but when the order was passed on 19th,
Yes, my lord. It was complied before that.
It appears that, no, but the date is different, but the date is subsequent.
Was the communication
March
date?
2024.
My lords.
To comply with the order in application, if not already complied. It appears that an order was already passed by Tahsildar on 19/6/2023 on the petitioner's representation, mentioning inter alia therein, mentioning comma inter alia comma therein, that the land in question was not reserved for any specified purpose, and that the construction was being made for community,
Center. My lords.
for establishing a community center.
Community purpose, that is what he raised.
For community purpose, for community purpose. So stop. The said order dated 19/6/2023 has been challenged in the present writ petition filed in the nature of public interest litigation. Next, learned counsel appearing on behalf of the petitioners has submitted that the nature of the land is pond,
My lords.
and therefore the construction is per se illegal. Stop. He submits that Tahsildar has recorded a wrong finding in the impugned order that the said land is not reserved for any specified purpose. Stop. Next. Exercising power of judicial review under Article 226 of the Constitution of India, we need not go into the correctness of finding of fact as to whether the nature of the land is pond or something else. Full stop. We do not find any merit in this writ application. We do not find any reason to interfere with the said finding recorded by Tahsildar Dalpada Daspala. So this writ petition stands dismissed accordingly. Yes.
Item 22.
So we will, I have to rise for some administrative. Any other matter?
Yes,
Yes, sir.
I'm sorry to make a mention, my lord.
Yes.
After lunch, I have got a matter fixed up pattern. Item number 32, we both are there. The money has been sanctioned. It is going to be released. Can it come on the next week so that all documents can be there?
Ask someone to be here, we will do it.
Yes, my lord.
I am. Monday. We both have.
Ask someone to be here when the.
Yes, my lord. When it is called somebody on our behalf, that will make a mention.
Item
Oblige,
number,
my lords.
item number 38, my lords. It is a restoration petition condonation of delay of 10 days.
Restoration, condonation.
Of delay petition, item number 38 in the list today. Yeah, it is short
In
matter.
the second half, we will take up. In the second half, is there any matter fixed for two?
Yes,
There
sir.
are 4 cases.
4 cases.
4 cases fixed. All right, 38, may you have you filed any interlocutory
Yes,
application?
yes. I have filed an IA application for condonation of delay.
38, is there any objection by other side? All right. This. In. All right, after we
Yes.
come back at 2, we will pass. We'll take up your matter.
Item number 22, which my learned just now, it may be taken up tomorrow.
May I please, I am the petitioner in person.
My PIL matter, madam. Kindly had it after lunch.
As you direct. But there are so many matters to be taken up at 2. And I had planned to go rise at 1. It is already late.
It can be taken up tomorrow.
My lord, item 24 may be taken up tomorrow. Item 20.
The parking. Which one?
Item 52, madam. May it please your lordship. My lord, in this case, your lordship, the question involved regarding this qualification for the post of junior fishery technical assistant.
That we have heard.
My lord,
We have heard at length.
my lord, your lordship
And
only.
we are of course tentative view that they are right in their submission, that we cannot alter.
My lord, your lordship may kindly only permit me to place only 2 lines from the record and nothing else. My lord has made a query on that day whether we know swimming or not, and whether it is part of the.
No, that was just a.
My lord, only your lordship,
something.
I am filing an affidavit, only 1 line, nothing else. So I have served a copy to my learned brother also, that swimming is never a part of curriculum in neither in +2 vocational nor in diploma fishery. It is a self-declaration to be made by the candidate. Only 1 submission, my lord, that my learned brother relied upon the judgment of Johut Sheikh, wherein actually the requirement was matric with ITI, and it was not mentioned that any other candidate can apply. On that basis, the Honorable Supreme Court said when the provision clearly says only matric with ITI in that discipline, they cannot permit even if higher degree holders, but that is not in our case. In our case, they permit us. My lord, I have gone through it again and again to find out as to why this discrimination has been made to these people. When they say that we are better qualified and we can perform better, the reason, your lordship, appears from their affidavit only. Actually, my lord, this is a rule of 2013. And the fishery with diploma course started in 2012. And it is a 2 years diploma course. So by the time 2013 rule came into force, no fishery student with diploma were available. So our course has not been taken into consideration at all. And they simply say +2 fishery science are eligible and +2 science students can apply. They do not say that +2 science with diploma fishery students will be equal to fishery. Now, my lord, my respectful prayer before your lordship, that in any case, my lord has always held it that there must be a purposive interpretation. Now, if the rule serves any purpose, your lordship has asked them as to show them at least 1 line from the counter as to how we are unable. It is not there. I have annexed it and it is not there at all. They do not say. Now, only stand they take that this is our rule. Now, if that is their rule, your lordship, there must be some logic, some reason behind such rule. Otherwise, it will be arbitrary. They cannot say that because we say it is correct. They have to justify it with reasons. It must stand to the reasons and conscience.
Whether a person having, say, BTech,
my lord,
computer sciences is eligible for IAS or not?
Eligible, my lord. Eligible, my
What
lord.
is the nexus?
That is a different test being conducted. It is.
What is the nexus between this qualification and this job of IAS?
The job of IAS is open competition for all. So the nexus is not with the course, but with the test they are conducting. Whether that test 1 person qualifies.
Because that is the qualification which has been let down.
My lord.
That qualifies them.
That qualifies them, your lordship.
So every time it is very difficult for this court to find out nexus between the qualification and the post.
And the second thing is that, your lordship, my respectful submission, that they say that we are eligible. Once they allow us to participate in the competition,
There is a common competition. As your lordship said, in IAS, all persons can appear.
Sorry, we withdraw
My lord.
that comment.
No, with respect, my lord. But they cannot say that we'll give preference to these candidates. That is my submission.
All right, we'll see whatever.
My lord.
Then we can.
And one last line, my lord. I have gone through the judgment cited by my learned brother. It is clearly saying that if the rule doesn't permit, nothing can be done. Your lordship, I have annexed that rule in my case. In my case, your lordship, rule 20. I am reading it only one line. That is relaxation. Where the government are of the opinion that it is necessary or expedient so to do in the public interest. Page 38, I am reading, my lord. Page 38, the relevant portion of the rule. Where the government are of the opinion that it is necessary or expedient so to do in the public interest, it may by order for reasons to be recorded in writing relax any of the provisions of these rules in respect of any class or category of persons. My lord, my prayer before your lordship, that are the candidates, those who are contesting the matter. My lords have permitted us to appear the examinations and we have appeared examination. We have scored thrice more marks than other can. It is not a question that other diploma
Mr. This submission you have made for 25 times. You are not required to repeat that.
My lord.
And if you want, you can make your written notes of argument. We will see that why.
My lord, my prayer is that your lordship, under rule 20, at least the petitioners, because in Jahur case also, Honorable Supreme Court said the appellants, only they will be given 2 years relaxation. So others are fence sitters. We are before your lordship. So your lordship may consider our position and may take into account rule 20 also, that these petitioners at least, they may be, because that the rule permits. And in Jahur case also, your lordships have said that only the appellants will be given 2 years relaxation and no other person will be given. That is the judgment cited by my learned brother. So my prayer is that your lordship, these petitioners for this time only, because 212 posts are there. We are only 15 petitioners. 212 posts they are advertising. Considering the plight of these petitioners, your lordship may kindly even direct under rule 20 that they may be given equal opportunity this time.
We will never do that.
My lord.
If we do that, we will be doing for everyone, not for these petitioners only. All right. The Supreme Court may pass orders, as has been passed in other cases, but we will not, never. All right. Our orders will not be confined to these petitioners only if such orders violate Articles 14 and 16. All right. So if we we'll allow everyone. Otherwise, we decline. That slip shall be declined to everyone. Yes.
I have already filed a written note of submission.
Yes.
I have already concluded, madam.
You can give your written notes.
I have already filed, my lord.
That will help us.
I have already filed.
Item number 63.
My pleasure.
Before my should be taken.
Affidavit.
Item 63. Item 38 was received. So I was praying for an accommodation. Or in the alternative, if my lords will accept. I'm digging the petition, so digging will give a reply.
In fact, honestly speaking, that submission of yours relieves us also. Temporarily, but yes.
Temporarily.
Yes. So what should we do?
But I propose, not haphazardly. Today I'll do. Why not, your lordship, keep it a particular date so that the
farm date be fixed so that all of
us can be heard. You see, that matter, lordship, hard just a rule was there in 1993, just for a moment. And in 2003, because of the financial problem, they said that they issued a resolution that all the sanctioned vacant posts to be filled up by way of
contractual appointment in secondary schools. They made the procedure, but these rules, whatever procedure is there, that procedure will be followed, but the appointment will be made on contractual basis. And in 2004-5, these people were appointed. And in 2011, a circular was issued by the government that on completion of 6 years of service, their service will be regularized against those sanctioned posts, and they will be treated as a government employee for all purposes from that date, on the date of completion of 6 years. Then likewise, they gave appointment every year, 2012-13, on the basis of that earlier circular of 2003, and they are also regularized. For the first time in 2013, they made a rule under Article 309, contractual appointment. In supersession of all rules and government circular, appointment will be made henceforward on contractual basis, and a provision was provided that on completion of 6 years, same thing, that they will be deemed to have been regularized in that post. So on the basis of 13 rule, in fact, the appointment was started in 2016. Persons, those were on 13 rule. But in the meantime, those persons, those were appointed in 2012-13, they completed the period of service of on completion of 6 years. Their service were regularized also. But in 2022, they repealed the provision of 2013, wherein they said those persons, those were appointed under 2013 rule, they will get the benefit of all national benefit and everything with effect on the date of their initial appointment as contractual. Whereas the contractual appointees who have been already regularized way back in 2011 or 2012 after completion of 6 years, they have been excluded. This is the sum and substance. And what they have done, after this rule came into force in repeal rule came into force in 2022, they
have those who were working already on contractual
basis.
Would they have applied after 2012, 2013 rule? Whether they were required to apply or not, or whether there was any requirement for them to apply again for contractual appointment?
Not required. That was not also that was not required. The only is, this is why virtue a rule under Article 309, they were appointed by virtue of a resolution or executive instruction, despite the rule was in force, 93 rules. Now they have been regularized in 2011. But unfortunate part is that those persons, those were appointed after 2013 rule came into force in 2016.
Everything, the main issue is as to whether those persons who were appointed prior to 2013,
right, sir,
whether they were also required to apply under 2013.
No. By that time, they have already regularized.
Already regularized. So they were not required.
No, not required at all.
Or they were already already regularized, therefore.
And more important, after the rule also, the repeal provision was made, they have made a SOP, 2 SOPs. In the SOP, they have now said that Group A, Group B, Group C. Group A, those persons were appointed after 2013 rule came into force. Group B, those persons were appointed prior to 2013, but they have been regularized after 2013. And Group C, we are the persons. Those who have already been regularized by virtue of the executive instruction in 2011. And so far as we are concerned, no benefit at all. But so far as Group A is concerned, all benefit right from the date of appointment. Now, by that process, we are losing 6 years of service.
So has he been able to prejudice our mind?
Sorry.
We are ready in the matter. We are ready in the matter. So we say that our stand is 2013 rule stands different. It can't be what my non-senior with respect to what the submissions forward now. That because they were appointed in 2011 after 6 years, they were regularized, and now because of 2013 rules were appointed, they are regularized.
No, was there any difference between the process of entry based on resolution before 2013 and post 2013?
The biggest difference was under 2013 rules, the persons appointed, they had the knowledge that after 6 years they will be regularized. But all these appointments, they were not given such facilities.
So you could have.
Yes, we have. That's what we are going to place.
Or we will see. So we will hear both of you with open mind.
Yes. Your Lordship will fix any date.
Line will be only the benefit of regularization.
After vacation.
That's right. Keep a date so that at 2 o'clock, so that we can be ready.
has jointly requested on behalf of the parties list this matter on, these matters on 10th July.
At 2 p.m.
2 p.m. to be taken up at 2 p.m.
Item number 70.
Right, Judge. The petitioner is a law college malus who got the permission from the Bar Council malus from the 1993 and recognition from the state government malus and affiliation from the Uttar University. From the beginning from 1989 to till 2022, there was no disturbance malus. The students were appearing the examination in every year malus. In 2023, by the annexure malus, annexure.
Just a minute, sir. 62 gas, 62 is a long matter. How many? So many guesses. Yes.
The petitioner is a law college malus who got the permission from the Bar Council malus in the year 1993, recognition by the state government, affiliation by the Uttar University malus. The Madhusudan Law University was established in the 2021.
University.
Madhusudan Law University. That was affiliated from the beginning from the Uttar University. After establishment of Madhusudan Law University, all the affiliated colleges were transferred to the Madhusudan Law University malus. And the first time malus from 89 to 2022, there was no disturbance. In 2023 malus, they given a letter to comply some of the points malus. We complied the points malus. Then malus, by the annexure.
Who are you?
Malus.
Who are you?
I am the principal malus.
You are principal of what?
Principal of the college malus.
Which college?
That is Vishwaguru Law College. Vishwaguru Law College, which is situated in Cuttack. Vishwaguru Law College.
Yes.
Kindly turn to malus, annexure 13 malus at page 49.
Yes.
When the university, Madhusudan Law University wrote all affiliated law colleges to took admission in +3 and +3 in 3 years LLB and 5 years LLB malus. We took malus that is in the said letter malus. My college name was there. That must to page 50 malus. Page 50. Turn to page 49 first malus, annexure 13. Principals of all affiliated colleges.
Page 49. Yes.
Principals of all affiliated colleges, that is completion of admission into 3 years LLB and 5 years BLLB course for the academic session 2023-24. And it was directed to the admission process should be complete by 30th September 2023. And in next page malus, page 50, my college name was there malus. That is in the last but one malus, that is Vishwaguru Law College, Principal Vishwaguru Law College.
Where is that?
Page 50 malus, last but one.
Page 50 is nothing.
Page 50, my lords, that is only the affiliated college's name was there.
Yes, and mail.
That is, please.
Mr. Counsel, because mail was sent to you, therefore you are affiliated.
No, because all the affiliated colleges and mail was sent to the all affiliated colleges.
So
my
you
lord. All,
become affiliated because of that mail.
my lords.
Because of that mail, you become affiliated.
No, affiliated, my lords, affiliated by the youth congress.
So there is no dispute about that.
There is no dispute, my lords. They sent all the affiliated colleges to mail to took admission.
Again, we are repeating the same question that
Yes.
if had this mail been sent to you, you have become affiliated college. So whether you are relying basing your case on this communication that you are affiliated college.
No, there is no dispute that I was affiliated college.
All right.
There is no dispute.
No, you mean to say this letter has been sent to all the principals who are
Yes.
all mailed.
Yes, ma'am.
And
That is
your
what-
name also finds place as a person who is already affiliated, and this letter has been sent to you
yes,
as treating you to be affiliated
colleges.
college.
Yes. Then, my lords, the students took admission in the college, my lords. Then, my lords, when we have deposited the registration fees, right, my lords, by the annexure, page 53, my lords, we deposited the registration fees for students, my lords, that is 3,150 per 50. Right, annexure 15, they say that this letter is not in your contest. My lords, annexure 15 at page 54. Page 54, my lords, annexure 15. In continuation to the earlier letter so and so, it is hereby informed that a mail sent on 4/9/2023, which referred to principal of all affiliated law colleges under Madhusudan Law University, is not in your contest. In your case, letter by MLU so and so stands as it still continuing for the purpose mentioned in the letter. And in next letter, my lords,
Yes, please.
and in next letter, my lords, the annexure 16, the same thing was given to the principal in charge, my lords.
Yes.
And that is, they refer to the letter dated 6/5/2023, my lords,
Yeah.
which I have annexed, my lords, at the annexure 7.
Yes.
Annexure 7 at page 24.
Yes.
That in pursuance of the statute 182 of the Odisha University First Statute 1990, the syndicate has accepted the inspection report of Sri Vishwaguru Law College, Cuttack, and directed to inform the college authority so that the college may not be allowed to admit the students for the academic session. Where that has not been, where the shall not, may not, because I have complied because by virtue of this letter, conditions to fulfill the college, I have fulfilled the college matters, all the compliance matter by the annexure 12. That is on 26/1/2023. After fulfillment of the compliance report, my lords, they sent the letter to all the affiliated colleges to admission.
So after this 6/5/2023.
Yes, I have complied the report, the report, my lords.
Just a minute.
Yes.
After 6/5/2023, did you apply for fresh affiliation?
Yes, my lords.
When?
That is, my lords. That is at page, my lords. That is page 31, my lords.
Applied for fresh admission when?
Page 31. Page 31, my lords.
What is the date? Why are you not?
That is, my lords, that is on 5/6/2023.
5/6/2023.
Yes. I have deposited 3,50,000.
Just a minute. So whether on this application, any decision has been taken by the university?
No decision was communicated, my lords.
So you are not an affiliated institution.
No, they have never said that it was a de-affiliated.
It is clearly mentioned in this 6/5/2023. However, if the authorities feel that they meet the following conditions before the academic session so-and-so 2024-25, they may apply for fresh affiliation to Madhusudan University.
Yes,
So
but
your college was not affiliated.
because once I have, just one, once I have,
See, therefore, in the very beginning, we observed that are you basing your claim only on the mail which was issued?
yes, madam.
So that is nothing.
And
The wrong and whatever. Therefore, we also observed that had that mail been sent to you, whether you would have become an affiliated university or not.
because once, my lord, that is the question, then the question of de-affiliation will arise, my lord.
No, there is a question of did you challenge this 6/5/2023 order?
6/5/2020 letter, 22 letter, my lords.
23.
6/5/2020 letter. I have compliance tablet compliance.
You complied with, therefore you admitted that your college was not affiliated.
Because by the annexure, just annexure 12, my lord, just told me annexure 12, my lords. I have complied all that, all the points.
You might have complied, but the question is whether you are affiliated or not. That is the question. That is the simple question.
There, my lords, their point of view, there is no de-affiliation. Then the question of de-affiliation will arise. Then as per the Odisha first statute, my lords.
All right, let us see your application. 5/6/2023.
5/6/2031. That is at page, my lords, that is page 31. For 3 years, my lords, I have deposited 3,50,000, my lords.
Page 31.
Yes, my lords.
What submission you are making?
Deposit of BCI fees for the session 2020-21, 21-22, 22-23.
What is this? There is no connection between what you are submitting and the document which you are showing to us. The university asked you to submit an application for fresh affiliation. You are saying that you did it by 5/6 by your application dated 5/6/2023. This application is addressed to the Bar Council of India. And that is BCI fee, not for affiliation.
Affiliation, members, they have never declared that they are the de-affiliated. I have deposited the affiliation fees, members. I have deposited the affiliation fees. There is no dispute that we have not deposited the affiliation fees, members.
It's difficult to convince you. Yes.
Mr. Bera.
My lords. Yes, my lords. My lords, still, your lordship in the last occasion has directed me to file an affidavit that till 6/5/2023, none of the students are being affected. We have taken them to our university, our campus, and they are appearing, and their academic curricular activities has been taken care of. Second, my lords, your lordship's direction on the maintainability of the present petitioner, my learned, with greatest respect, my learned senior submitted a wrong fact that he is not the principal in charge. In fact, my lord, from his own averment, it is clear there is nobody principal now, my lord. The government has appointed Professor Dr. Padan Kumar Jena as a special officer. In fact, the present petitioner has got no locus standi to file any application. That is why, rightly, your lordship may kindly have your lordship's order dated 29/11/2023, where the petitioner was to satisfy the locus standi, my lords. That has not been done, my lords. And my lords, your lordship's question with regard to the order dated 6/5/2023, my lords, that order has not been challenged. That order has not been complied, and the college, in any manner, my lords, has not filed any application before the authority, university authority, to consider for admitting the students, my lords.
So, who are you?
But I am the principal in charge, my lords.
If you are the principal in charge, then you are bound to destroy the career of all the students of the.
No, because letter was addressed.
Because you are acting not in the interest of the institution, rather contrary to the interest of the institution.
Because all the letters
If you have approached this court deliberately to destroy the institution itself by taking some order from this court, then it's a different matter.
No, my lord,
Otherwise,
because 21 students, my lord, because they have wrote a letter to the affiliated, all the affiliated colleges.
all
so
right.
so we have so we have taken admission, my lords. The students, the career will be jeopardized, my lords.
Their career will not be jeopardized. Let the students come.
No, it is already
Huh?
paragraph 2 of the affidavit.
Affidavit filed
The
by the
university.
university.
Registrar of the Madhusudan Law
But
University.
here does not have any
The
locus.
university has taken appropriate steps in the interest of students.
You
Those
don't
who
have any
taken
locus.
admission in, so prior to 6/5/2023, those who have all taken admission, they have taken care of it. But after that, they have not. It is their own risk.
The controversy in the present rate application relates to the status of affiliation of Viswaguru
Sri Viswaguru Law College.
Sri Viswaguru Law College, comma, Sikharpur, comma, Cuttack, to Madhusudan Law University, Bhubaneswar.
The Cuttack, my lords.
Cuttack. Madhusudan Law University is in Cuttack. Cuttack.
Yes.
Stop. It is the petitioner claims to be the principal of the said law college. When this matter was earlier taken up by this court on 9/11/2023, comma, question had arisen as regards the petitioner's locus standi to maintain the present writ petition and petition, his claim that he is the principal of the law college was disputed by learned counsel representing the university with a contention that in the absence of a regular principal of the college, one Professor D. Padam Kumar Jena has been appointed as the principal of the college.
No, so he was appointed as a special officer, not principal. He was appointed as a special officer by the state government. That is their letter, my lords.
His claim that he is the principal of the law college was disputed by counsel represented in the university, that the contention that in the absence of a regular principal of the college, one principal.
One Professor Dr. D. Padam Kumar Jena has been authorized to
His claim that he is the principal of the law college was disputed by counsel representing
the university, and it was argued that the management of the institution had been handed over to a government official, namely Professor Dr. Padam Kumar Jena. Full stop. How is he not principal? There must be some principal of the college.
Yes, I am
No,
continuing as
Manoj,
principal. There is no.
because there was no management committee, the government has appointed Professor Dr. Jena as the administrative head and financial head of the college. And
No, but-
coupled with the fact that the college has been de-affiliated and their management has not been constituted, no principal has been appointed.
Next. Be that as it may, comma, from the documents brought on record in the present proceeding, it transpires that the university had issued a letter on 6/5/2023 requiring law institutions, law colleges to fulfill certain conditions. First off, the opening paragraph of the said letter reads as under page 24 in pursuance of so and so. However, if the authorities feel last sentence were blocked. Stop. Next. Learned counsel for the petitioner has submitted that in the light of the said communication dated 6/5/2023, the college had applied for fresh affiliation to Madhusudan Law University on 5/6/2023 by drawing our attention to annexure 9 to the writ application. Stop. The petitioner does not dispute the existence of, they said, thus does not dispute the existence of the said communication dated 6/5/2023 and has taken stand that application was filed for press affiliation. Stop. There is no application available on record for press affiliation. Stop. The said letter dated 5/6/2023 is addressed to the Bar Council of India for deposit of BCI fees for the sessions 2022 20-21-21-22-23. We should impose cost in this case.
Sorry, my lord.
2023. Stop. The said letter does not relate at all to the academic session 2023-24. Stop. In any case, that is not an application seeking affiliation of the law college to the university. Stop. Learned counsel appearing on behalf of the petitioner in the present writ application has sought for quashing of the orders dated 30/9/2023 and 7/10/2023 issued by those both by university.
Yes,
by the university. First off, the petitioner's case is precisely based on a communication dated 4/9/2023 issued by the university through email. First off, the said communication was sent to principals.
Yes, principal to all the affiliated colleges.
To the law colleges, including the present law college, including Viswaguru Law College. First off, based on the said communication only, solely based on the said communication, the petitioner has claimed that the said college is affiliated to Madhusudan Law University. First off, next, it is not in dispute that the said law college was earlier affiliated to
Utkal University.
Utkal University,
and subsequently Madhusudan University.
That affiliation is not there.
Yes, my lord, that all the colleges are transferred to Madhusudan Law University.
That affiliation order is not there.
Because all the were transferred, my lord.
It was. What's up? Next.
It is not in dispute that the same law college was affiliated to
Utkal University. Affiliated? It was affiliated to this Madhusudan Law University also?
Yes, my lords.
Affiliated.
My lords, all the colleges were
affiliated to Utkal Law University, and subsequently with the creation of Madhusudan Law University, all such law colleges which were affiliated to Utkal University, by operation of law, stood affiliated to Madhusudan Law University. First off, the fact, however, remains that by virtue of the said letter dated 5 after issuance of the said communication dated 4/9/2023, another communication was made to the present law college by the university through letter dated 29/9/2023. Sorry. Which is that letter?
39/2023.
Yeah, 29/9/2023. Where is that? 39/2000.
Yes.
39/2023. To the effect that the said communication dated 4/9, said mail dated 4/9/2023, which was referred to the principals of all affiliated law colleges under the university, was not in the context of Viswaguru Law College, and in the case of Viswaguru Law College, the earlier letter issued on 6/5/2023 stood as it was and was still continuing for the purpose mentioned in that letter, that is press affiliation, application for press affiliation to be made by Viswaguru Law College. First off, as has been noted above, though a stand has been taken that an application was made for affiliation, press affiliation, no, the the petitioner has miserably failed to point out that any such application was ever made. First off, learned counsel appearing on behalf of the petitioner has vehemently argued that if the students of the law college who were admitted in the college when it had the status of an affiliated institute are not allowed to appear for the examination and pursue their further course, it will cause serious prejudice to them. Stop. An affidavit has been filed in this regard on behalf of the university, stating therein that, where have you said?
Well, that's para 2 of my affidavit, my lords.
That the students admitted in the college before 6/5/2023 have been allowed to appear in the university examination. First off, the university has taken appropriate steps in the interest of the students, and they are smoothly appearing in the examination without any objection. First off, further, those students, further, the university is ensuring that their academic and co-curricular activities are not adversely affected in any manner. Stop. Next. In view, it is worthwhile mentioning that the communication dated 6/5/2023 requiring the college to make an application for fresh affiliation has not been challenged by the college. Stop. For apparent reasons, the management of the college has been handed over to a government official.
As former registrar, Ravenshaw University.
To a former registrar of the university.
Ravenshaw University.
Which university?
Ravenshaw University.
Ravenshaw University. Stop. Taking into account all the facts and circumstances, we do not find any merit in this application, which is accordingly dismissed. Page 49. Just second. What is your age?
My age, my lords.
Hmm?
So one my lord, 50 years, my lords.
Huh?
It is
80?
number 50, my lords.
50. All right. And this annexure 11 relates to what?
Annexure 11. Annexure 11, my lord, that is special officer was appointed, my lords. By virtue of this letter, my lord, the special officer was appointed.
In your place?
No. He was appointed as a special officer, my lords.
So please come to this.
Yes, my lords, the last paragraph, my lords.
Not last paragraph. That is
Whereas the
what is-
prescribed authority,
as the principal has already overstayed for more than 6 years.
that is, my lord, the writ application was pending by virtue of this writ application, my lords, so they are continuing, my lords.
So this is what is mentioned.
Yes, my lords.
That you overstayed for more than 6 years. And you are holding the post of principal beyond
after 60 years.
attaining the age of superannuation.
It's a private college, my lords, that is.
So you are saying your age is 50 years?
No, that is in the petition number 1, my lords, I am continuing with 50 years. Petition number 2, my lords, that is. Petition number 2, my lords, with the principal, my lords, that is 66 years. Petition number 1, my lords, that 50 years.
Petition number 1 is?
He's my lords, that is, he's the full-time lecturer, my lords. 2 petitioners are there, my lords.
All right, we may impose cost, but you consider.
A writ application.
I'll add that part also.
A writ application was pending, that is on the same point, my lords, with regard to age of retirement, and that is my lord pending matters.
Yes.
Item number 75.
Leading to the tender of the documentary.
Yes.
I'm for the OP number 5. My learned seniors have all completed. I'll just submit, my lord. My lord, may kindly see section 56 of the Motor Vehicles Act, which prescribes for these centers to come up. Now, I'm just reading that proviso. Second proviso to clause 1 of section 56, which deals with certificate of fitness of transport vehicles. This is just to give a background as to why these centers are to come up and the urgency, because Rule 62 of the Central Motor Vehicle Rules.
No, there are 2 aspects,
my lord.
Mr. Mishra. First is that why at all that clause under 2.9 was there.
My lord.
So that amounts to excluding all the players in the field.
The litigation. There are 2 points. Yes. One is litigation history. The other one is rejection of the bid of the petitioner for non-payment.
No, we will come to that later.
My lords.
Now, first of all, if the state government or if it is prescribed in the tender notice that only those persons can apply, that is one of the conditions laid down. That they should not have any litigation pending. This is something impossible situation. So that is, we are of the prima facie view that we should interfere on that ground alone. And see, the question is that possibly a question may arise that it's a kind of public interest that because it was not open to everyone. Therefore, what prejudice has been caused to him? He has been not disqualified because of that clause. All right. But again, the larger question is there that this is how you exclude the competitors. So this is one of the questions. And then whether he qualified or he could not qualify or in what circumstance he has been, according to you, and we find force in that submission that it was specifically when there are 2 requirements. When the notice itself provides the consequence of non-compliance, then that becomes an essential condition. All right, according to them, it is not an essential condition. So
I'm grateful,
this
my
is the
lords,
background.
for the queries, my lords. I'm grateful for that. Now, in that background, I'm not trying to resist what falls from your lordship, but just to assist your lordship may first see section 56 of the Motor Vehicles Act, the second proviso. I'm just placing it. 56 deals with certificate of fitness of transport vehicles, and the authorized testing station refuses to, certificate has to be there. Now, my lord, may kindly see the second proviso. Provided further that no certificate of fitness shall be granted to a vehicle after such date as may be notified by the central government unless such vehicle has been tested at an automated testing station. This is the proviso. Now, initially, Rule 62 of the Central Motor Vehicle Rules had the dates in place. It was from 1st June 2024 onwards.
Please come again. Sorry.
My lords, section 56 deals with certificate of fitness of transport vehicles. Now, the second proviso makes it mandatory that this has to be granted by way of an automated testing station. So, after that deadline, no manual testing would happen. No human beings would be involved. It would be all automated. That is the provision itself. Now, under Rule 62 of the Central Motor Vehicle Rules, the deadline was initially fixed to 1st June 2024. After 1st June 2024, there would be no manual intervention. It would be all automated testing station. Now, this 1st June 2024 has been extended up to 1st October 2024. So this tender is vis-a-vis establishing these automated testing stations. And as I speak, my lords, the last date is 1st October 2024. After the extension, the original date was 1st June 2024. This is flowing from Rule 62 of the Central Motor Vehicle Rules 1980. So this is just the background, my lords. Just
But suppose,
my lords,
if we strike down
my lords,
that clause,
my lords,
then what will happen? If we find that that clause is arbitrary,
my lords,
then what will happen?
then probably they'll have to go with for a fresh tender. That's for this. I'm for the OP number 5.
We understand.
But probably then they'll have to go with for a fresh tender, having that clause modified.
Or can you develop an argument that that's kind of superfluous provision one could follow?
My lords, what falls from their affidavit, from the government's affidavit, is that that condition is just to allow the party to declare the litigation history, but that would not debar them from being.
Just see 29. Is that 29?
23.
23.
23.
My lord.
Please read that.
My lords.
At page 64, my lord.
Page 78.
Now, my lords, here, page 64, clause 23 says, declaration on non-involvement of legal litigation by bidder.
No, please come to 2.9.
2.9 is vis-a-vis the ground on which the petitioner's bid was rejected.
All right.
2 my lords, I get, my lords, I'll just to assist your lordship, there are 2 points.
Yes,
litigation history
right,
and rejection of bid.
All right, that is page 64.
64.
Just. So
64, clause 23. declaration on non-involvement of legal litigation by bidder or any other member of the bidder in case of consortium.
So now there are two aspects. 123 was reading 23 and then come to page 59.
No, in fact, the point against.
Yes. Yes. Not only that. See, please come to page 59.
My lords. Pre-qualification conditions.
Pre-qualification conditions.
My
So these are the conditions.
My lord.
Table 2.
My lords.
So 23 is part of the first column, second column of table 2.
My lords.
So that is pre-qualification condition.
My lords. Declaration of non-involvement of legal litigation by bidder or any other so and so.
And then come to note.
Note. All forms of this RFB required in support of technical bid conditions must be filled and submitted by the bidder.
So you excluded hundreds of the bidders. Not you, sorry.
What fell
Please
from
state.
the court, in fact, I was listening to your lordships. My lord was pleased to observe that in view of this clause, many might not have come.
Right.
That is something which falls from the court. But in their counter, they are trying to explain this by saying that if my lord would see the exact paragraph, that is there at running page 252.
No, but just think of a situation
My lords.
where only 3 bidders are there.
Lord,
Maybe because of this clause.
I would like to intervene, Lord. All the bidders here, Lord,
Fees for the state.
they are consortium of 3. Lord, opposite party number 4 is consortium of 3 bidders and OP number 5 also same. And the petitioner also 2 bidders. So, Lord, there was 8 bidders have participated.
That is different.
Yes.
That is different. 8 bidders, you might have had 80 bidders. So you are restricting the whole competition. And that is again apparently against public interest.
Lord, may I submit?
Your interest.
No, Lord, here that form S, that form S indicates only declaration.
No question of declaration. No question of that is the question which we had fought. That if you are a non-smoker and
Right.
put a question
Obliged.
that when will you give up smoking? Say yes or no. Will you give up smoking? If we put a question, if you are a non-smoker and if we put a question that whether you will give up smoking or not, yes or no, what will be your answer?
Answer would be no, but I am not.
No.
Yes. I am a non-smoker.
You have no answer. So a person who is facing litigation or who has filed any litigation, he cannot participate.
You will participate.
Now, this declaration, declaration, you see.
These are the situations where the government should rethink and retender.
So,
instead of inviting the court judgments. Well, that is something, and then that is we refrain from making those observations, but the reason is apparent.
From serial number 23 itself, that declaration on non-involvement of legal.
But that form says if you have litigation.
You are not saying whether you are involved or not.
All right,
Yes.
all right. Just see the difference. Just see the difference between non-involvement and involvement. So declaration in relation to involvement.
Lordship, kindly see that
no.
form S.
No.
Form S.
Form S we have seen. Form S, was impossible for a person having litigation to fill up.
Lord, the bidder has to simply say, yes, I have litigation and these are the litigation. That's enough. That is the commercial wisdom that condition is put. In order to know the litigation,
Where
of
is
a
that
bidder.
S? Where is that S?
Page
Page
78.
78.
So that was the ground for disqualification. That could have been, if page 78,
Yes.
that could have been valid ground for disqualification.
No,
Because of this clause 23. You could
No,
have
you
said
have-
that
You
from.
have, sir.
no.
You have added another thing in format. Their non-involvement in litigation. Here litigation and or
And there
stroke,
is slash.
or slash.
Yes, my lord.
Arbitration.
Arbitration history with the government department slash
Which page is
public
that?
sector
It is,
undertaking, private sector
78.
or any other agency for which we have undertaken the works, services during last 10 years. He has to only indicate.
If you read serial number 23 heading and this read together,
Yes,
the notion goes that you are harping at
but
non-involvement. You are
yes, my lord, for
asking a
that clause
person to be
23.
non-involved in any litigation or in arbitration.
Is not that clause for clause 23 he has
arbitration
to
also.
submit this declaration in Form S.
Arbitration.
Mr. Please tell us that if someone has litigation,
Yes,
then what will he do with Form S?
but he has to indicate these are the litigations pending.
Where is the question of pending? It says, we hereby confirm and declare that so and so does not have any litigation.
Yes, then
Where is the choice?
then my lord, arbitration history with any government or
So where is this is a format? Nothing more than after MS and before does could be filled.
And there is no asterisk to say that inapplicable words may be struck off.
but that itself is not a
That
ground.
is apparently this form is in consonance with 23.
But that is now, my lord, academic because
That is not academic.
my lord,
That is we are sitting in judicial review. If we see patent arbitrariness, then we shall surely interfere.
but here the bid of the petitioner has been preliminarily rejected on the different ground.
No, your very tender is we may say that's tented with malafide to favor people. You have restricted the competition.
So, Your Lordship,
So,
may
that is one.
I suggest one thing, my Lord? My Lord may keep this to tomorrow. We'll come back to your Lordships as to whether we can sustain such a tender where there is an absolute embargo on parties to participate without any litigation history. If this clause cannot be sustained, then
All
we'll
right.
come back to your Lordship.
All right.
Yes.
So can you have a look at paragraph
Yes, to assist you,
36, 38, my lord. That Supreme Court decision, Reliance Energy Limited, my lord.
To the players or the bidders who who are involved in litigation or who have litigation history, they can be debarred from participating in the tender process. That is the only legal question.
That is one, my lords. Another issue here would be that, of course, in the counter, they say that this is not at all required. They are trying to add that. If your Lordship wants, I can show that paragraph from the counter. But the other question would be here, if my lord would see the prayers of the petitioner, first prayer is rejection of the petitioner's bid on the ground of non-payment of taxes. That question, because that's the primary decision which...
That question we will not answer.
My lord.
Because if we decide first in yes, that can be done.
My lord.
Then the question is different. Then we can come to the second question. But if we decide the first question in no, it could not have been done, then the second question becomes redundant for the purpose of litigation.
My lord, here, my lord, there would be a small submission of mine that the petitioner is praying for quashing of the decision under Annexure 4 and to waive this litigation history condition vis-a-vis the petitioner. So this
that we will not entertain. His prayer to waive it, we will not entertain.
My lord.
In fact, we are of the view that in such cases, even public interest litigation could have been entertained by a person, a third party, by who is not interested, nothing.
My lord.
But when it relates to the revenues, state revenue, anyone could have approached.
My lord.
So even without, there is no question of waiver in his favor.
My lord.
So that we will not do.
My lord. My lord, of course, that would be opening the entire thing. Now, suppose, my lord, if I can submit today regarding the decision under vis-a-vis Annexure 4 and how the petitioner's bid could not have been accepted, then your lordship, I'll quickly run through those clauses because there are specific clauses and how the petitioner's bid could not have been accepted. So, if your lordship wants, I will, with a caveat that regarding this litigation history, I'll come back to your lordships tomorrow. So, my lords may kindly see.
No, but you will have to address that question first.
My lords.
If you satisfy, then we shall travel to the other question.
Then I'll not waste your lordship's time today.
Otherwise, that will be
because
if we are satisfied on that, then we can come to the second question.
My lords, what my submission was that the petitioner has come before this court saying that it has paid excess amounts.
That we will take note of.
That's incorrect.
We are sure that whatever stand has been taken by the parties, that will form part of the judgment.
My lord.
But we may confine our decision on the first point.
Litigation.
And we may say that in that background, we are not addressing the second issue.
But you also may take note of
this is our tentative view.
My lord.
Again, we are open to. Which paragraph you are referring to? Of this
paragraph 36, 37, and 38. This is actually one of the conditions that was there in the tender itself that was taken note of, and the lordships have come to a conclusion. We find merit in the civil appeal. Standard applied by courts in judicial review must be justified by constitutional principles which govern the proper exercise of public power in a democracy. Article 14 of the Constitution embodies the principle of non-discrimination. However, it is not a free standing provision. It has to be read in conjunction with the right conferred by Article 21 of the Constitution. The said Article 21 refers to right to life and includes opportunity. In our view, as held in the latest judgment of the Constitutional Bench of the 9 Judges Bench, I.R. Collier versus State of Tamil Nadu, Article 21 and 14 are the heart of chapter on fundamental rights. They cover various aspects of life. Level playing field is an important concept while construing Article 19(1)(g) of the Constitution. In this, it is this doctrine which invokes by Reliance and Maharashtra State Road Corporation in the present case. When Article 19(1)(g) confers the fundamental right to carry on business to a company, it is entitled to invoke the said doctrine of level playing field. We may clarify this doctrine is, however, subject to public interest. In the world of globalization, competition is an important factor to be kept in mind. The doctrine of level playing field is an important doctrine which is embodied in Article 19(1)(g) of the Constitution. This is because of this doctrine provides space within which equally placed competitors, but here this is a question that arises. Equally placed competitors are allowed to bid as to subserve the larger public interest. Globalization, in essence, is liberation of trade. Today, India has dismantled license Raj. The economic reforms introduced after 1992 has brought in the concept of globalization. Decision to our act, which results in unequal or discriminatory treatment, would violate the doctrine of level playing field, embodied in Article 19(1)(g). Time has come, therefore, to say Article 14, which refers to principle of equality, should not be read as a standalone item, but it should be read in conjunction with Article 21, which embodies several aspects of life. This is one more aspect which needs to be mentioned in the matter of implementation of the aforesaid doctrine of level playing field. According to Lord Goldsmith, commitment to the rule of law is the heart of parliamentary democracy. One of the important elements of rule of law is legal certainty. Article 14 applies to government policies. The policy or act of the government, even in contractual matters, fails to satisfy the test of reasonableness, then such an act of decision would be unconstitutional. Then 37, referring to that Union of India and International Trading Co., the division bench of the court speaking through Justice Panchayat held, it is a straight law that Article 14 of the Constitution applies to all matters of government policy. The policy or any action of the government, even in contractual matters, fails to satisfy the test of reasonableness, it would be unconstitutional. Para 15 has been quoted from that decision. While discretion to change the policy and exercise of the executive power, when not trampled by the statute or rule wide enough, what is imperative and implicit in terms of Article 14 is that change in policy must be made fairly, should not be given an impression that it was so done arbitrarily or by ulterior criteria. To wipe the wide sweep of Article 14, the requirement of even state action qualifying for its validity on its touchstone irrespective of the field of activity of the state is accepted tenet. The basic requirement of Article 14 is fairness in action of the state and non-arbitration in the sense. Substance is the heartbeat of the fair play. Actions are amenable in the panorama of judicial review only to the extent that state must act validly for a discernible reason, not whimsically for any ulterior purpose. The meaning and true important concept of arbitrariness is more easily visualized than precisely defined. Question whether an impugned action is arbitrary or not to be an ultimate answer to the facts or circumstances of the given case. A basic and obvious test to apply such cases to see whether there is any discernible principle emerging from the impugned action, and if so, does it really satisfy the test of reasonableness? When tenderers are invited, the terms and conditions must indicate with legal certainty, norms and benchmarks. The legal certainty is an important aspect of rule of law. If there is vagueness or subjectivity in such norms, it may result in unequal, discriminatory treatment. It may violate doctrine of level playing field.
We will see.
Exactly.
Mr. Roshi. That is the only question. That is the question, and
in fact, these clauses are now coming up recently in all tenders. But what I get from the court is that there can't be this absolute bar.
it's like blacklisting.
Right. It can't be. You have to declare your litigation history, but that can't be a. But the counter of the state says that it's not a.
Counter will not improve
the condition itself.
That was the
Mahendra Singh Gill's case is there, paragraph 8.
and then what did you what was conveyed by that notice to everyone?
Right.
And this tender notice could have been challenged by any person.
We'll get back to your lordship. Can I request that on Wednesday at 2 p.m.?
All right, Wednesday at 2 p.m. Because
Day after
matter,
tomorrow.
Yes, sir.
I must point out that we are appearing suo motu. The other successful party has not been noticed yet. That
No,
is something.
actually, no. They are only the shortlisted for the.
they are that's the
No, they can, sir. I don't have no objection. He is there to address.
No, I can't represent the other bidder. I'm for the one bidder. There is one more bidder, but I'm not standing. In fact, if your lordships on that day, your lordships can take a call whether.
all right.
If I'm able to show something to convince your lordships.
Who is the other bidder?
OP number.
No one is appealing.
Nobody is up.
So if required, we will pass interim order and then.
My lords. As on date, it's there, like no further kind of. It's
We have
been
not
just evaluated.
proceeded. We
They
have not
because of
proceeded
the
with.
pendency, they have not
finance.
If you proceed, you will be in trouble.
No, oh, Lordship directed on that day, I have made a submission. The financial bid has not been opened.
These are, Mr. See, we are making observations,
Yes.
open observations.
Right.
You also here. You must be realizing the bad consequences of such stipulations in the.
So I will examine, but this condition,
You advise your client
My lord.
properly.
no,
They
but
should-
this condition,
Otherwise, see, the comments from the courts in such matters.
yes,
See, say on your reputation also.
Right.
well, I'll satisfy my lord. On
Yes.
Wednesday.
You are there.
Maybe request Wednesday at 2 p.m.
Wednesday 2 p.m.
We are grateful to you.
Weekly list item.
That cannot.
Item 22, the last. Item 28.
Yes,
The restoration matter which,
restoration.
item 38. Item 38.
Normally we don't do it, but in your case we are doing because restoration matter, continuation of delay. We can restore also.
Your lordship. Your lordship.
38.
This is also a covered matter also.
Edits we are not doing
Your lordship.
at this stage.
Your lordship. Good.
IN number 207. So, main matter, my friend. Main matter. This application has been filed for a restoration of WPC number 11053 of 2018, which is to dismiss for default on 11/1/2020. Stop. This application is barred by limitation. Stop. There is delay of 10 days in in filing the present application. Stop. IN number 207 of 2024 has been filed seeking condonation of delay. Stop. Considering we have heard learned counsel for the petitioner and learned counsel representing the state. Stop. The facts and circumstances, the delay stands condoned. Stop. Further, the application is treated to have been taken for admission. Stop. this application seeking restoration is allowed. Must of that WPC number so and so be restored to its original file. Urgent copy.
Because they have to produce it before the authority.
When?
Your lordship may be kindly.
When will you produce? Just let us know, let us know.
So I'll be producing it before the authorities any moment because they may take coercive measure
All
against
right.
me.
So you will have to produce a copy, certified copy of that order,
Restoration.
a restoration order on Wednesday
No, no,
before us.
no.
No. We are the,
No,
before
Mr. Rath,
us.
Mr. Rath, my lord
Very-
impresses on bar that you get certified copies within 1 day or 2.
So you make an application online.
No, madam.
You tell us on Wednesday that we have got the certified copy. We want to know.
No obligation.
All right.
I got it.
Got the message?
Maybe listed before the roster bench next.
Let the WPC so before listed before. Is that a single bench matter? Or
No, my lord.
all right.
Division bench.
Division bench.
Appropriate.
Item number 22.
May I please? Here is a case of public interest litigation concern. I belong to Panchayat area.
Panchayat?
Area. I belong to rural area. I constitute the Panchayat and middle level is Panchayat Samiti and upper level is the Jilla Parishad. Your question is whether the representative of Panchayat institutions as elected Sarpanch and PS member can join and hold the party post and use the political symbol in his tenure, 5 years. Opposite party 1 to 6 year government authorities. 7, 8 appointed authority, the Sarpanch and PS member as political post.
Please read paragraph 1. Do you know what are you doing?
Yes, Milord. I am concerned about the interest of the public.
Yes. So be careful.
Yes, Milord.
Come to paragraph 1.
Milord.
So what do you want?
I want to elected Panchayat representative cannot join in political party, cannot hold any post from the political party, and also not use any political symbol in his tenure. Because
No, but you are confining your prayer to BJD only, not other political party.
other, yes, Milord.
And he has included only
Just-
that party as a.
Only one document I collected from the political party.
So you have grievance against the person joining BJD.
Yes, Milord. Particularly, so far my case is concerned, I collected some letter in his party website and his office of the Samiti and from Panchayat office. And there
What do you do?
my small prayer,
What do you do?
I am a legal practitioner.
Legal
This
practice.
annual court, I belong to rural area, Panchayat area, and I am concerned about my Panchayat and also my Panchayat
please.
Samiti block.
You are referring to law.
Milord? Yes. Direct statute, no statutory right, no constitutional right to the representative of the Panchayat institutions. They cannot hold the post of party post or use the party symbol.
Where is that?
Milord. Milord, according to the 73rd Amendment of our Constitution, it envisages the Panchayat Raj system. Kindly see.
73rd amendment.
Forget 73rd amendment, come to this. Where is, what prohibits them?
Statute मिला.
What prohibits them
Prohibit.
joining a
Mila.
political party?
ये मिला. Odisha Gram Panchayat Act 1964, Section 143. Members and servants of a Gram Panchayat to be public servants.
Just a minute.
मिला.
Which section?
Section 146. Miscellaneous chapter XIV, section 143. Statute, no statutory right there. All members of a Gram Panchayat or of any committee thereof constituted under this act, and all officers and other employees of a Gram Panchayat, every contractor or agent appointed by it for collection of any tax, toll, rates or fees, and every person employed by
Whether a minister is a public servant or not.
Yes, my lord.
So he cannot join any political party according to you?
No, my lord. Panchayat Raj, I point out from the beginning, 73rd amendment. So only motto is strengthening the self-government. In grassroots level, only constitution motto is to strengthen the self-government. Decentralization of power to strengthen the grassroots level, Panchayat Raj.
Sir, council,
Yes, my lord.
this is not the place for making political statements. All right, you
Yes.
tell us what prohibits.
143 says
143 is nothing.
being public servant. Panchayat members, sarpanch and the Samiti members are public servant. Reported judgment, case law is there below. Sarpanch is a public servant and is employed in connection with the affairs of the state.
Mr. Council, when did you join Bar?
2000.
2000?
Yes, ma'am.
You have been here for 24 years.
This
And you are referring to this citation in the court of the Chief Justice.
2000.
Because citation is there in the book, statute book. Have you gone mad or what?
Being public servant, only question is being public servant cannot join any political party.
The petitioner has filed the present writ application in the nature of public interest litigation, seeking a direction from this court to restrain the elected members of Gram Panchayat from joining political party and campaigning for the ruling party BJD with political symbol in Hatadihi block and Bancho Gram Panchayat. Top learned counsel for the petitioner has drawn our attention to section 133 of Odisha Gram Panchayat Act 1964, that the members of the Gram Panchayat or of the committee constituted under the Act and other employees of Gram Panchayat are public servants, and therefore they cannot join the ruling BJD party and campaign for the said party. Stop. The prayer which has been made in the writ petition is preposterous. Stop. This application is accordingly dismissed. Stop. We intended to impose exemplary cost for filing such frivolous writ petition in the nature of public interest litigation. First off, we, however, refrain from doing so, the petitioner himself being a member of legal profession. First off, yes.
Item number 23.
Lordship's order has been completed, the filing the complaints affidavit, Lordship, and I've given a copy to my friend. The order has been completed, the proceeding, sealing proceeding has been disposed of by the Tahsildar.
No, this is, as I received today, I have gone through the affidavit somehow. The area is more than 1,000 acres
So
more.
you can challenge that order. You can, we will give you liberty.
But the plot number was mentioned, the area is shortage matter.
All right. So if there is any grievance with the said order, you can challenge that in appropriate forum. We cannot do anything. There was direction for something that has been done. So you can challenge that. All right.
That observation.
It is stated by learned AGA that this court's order, violation of which has been alleged in the present contempt application, has been complied with. First off, a copy of this compliance affidavit is taken on record. Compliance affidavit filed by learned AGA is taken on record. First off, copy of the said affidavit has been served upon learned counsel for the petitioner also. First off, next, it goes without saying that the petitioner shall be at liberty to question the correctness of the decision taken for is there any order passed?
Yes, sir. Either the sealing proceeding or directed to dispose of has already been disposed of.
Liberty to question the correctness of the decision taken subsequent to this court's order, before appropriate forum in accordance with law.
Item number 24.
May I please, sir? I filed this contempt application, my lord. 2 orders of this honorable court has been violated. My lord, fact of the case is like this, my lord. A patch of land is applied for to establish a coal washery by the petitioner company to the state government and
just let us see what is the order. Where is the order?
my lord, interim order as page 10.
Page 10 has been disobeyed.
It's an interim order, my lord. It is continuing. It relates to a railway siding. Which has been given to the petitioner to run a coal washery.
So which order has been disobeyed?
My lord, this order, because what they have done, I have a coal washery.
Which order? Let us see the order first. Which order has been disobeyed?
My lord, first order is page 20. Page 20, till the allotment of alternate land is made for shifting of the coal washery unit of the petitioner company, they shall not be evicted from the land in question. And
so this order was passed when?
This order passed relating to a coal washery, my lord. Second order.
That is the answer. We are saying when was the order passed, you are saying.
This order was passed on on 6/5/2014.
6/5/2014.
Yes, my lord.
So this order has been violated.
Yes, my lord.
All right. Then
another, this order was until a patch of land is provided by IDCO, will not shift our washery to that land. The coal washery is still there. Another railway siding is provided by MCL. Because without railway siding, coal washery cannot run. So when railway siding, we have paid the lease rent till December 2023. And the coal washer is running and the railway siding is there. But now what NCL has done, they have disconnected the railway line.
So,
Both are defunct.
so where is the disobedience of the order?
My lord, disobedience of the order means, my lord, railway
Disobedience of the order means that if someone decides
Yes, my lord.
not to comply with the order, that is disobedience.
Not to comply, my lord, it is indirect way they have.
There must be some indirect that can be done.
My lord, by this way, my lord, both the railway, I mean to say the coal washery and railway side both are closed, my lord.
That can be cause of action, separate cause of action, which
My lord, when they failed to shift us, they have done this.
and what is where is the matter still pending?
Yes,
WPC,
still pending, and this matter is the interim order which has been passed. That is posted to 26th June, my lord. For vacation of the interim order.
13 matter is pending.
Yes, my lord. Because coal has been supplied by NCL. Nobody will supply the coal to the coal washery. They have taken lease rent.
So this was disposed of.
First matter is disposed of.
Yes.
Second matter is pending.
Which
railway siding matter is pending.
Where is that?
The interim order, which has been passed, my lord, that is pending.
WPC number 24730 of 2013 is disposed of.
Yes, 11425 of 2017 is pending.
Where is the order passed in that case?
Page 10. Since this matter is now ready for final hearing, let it be listed on 19/2/2024, interim order extended. Thereafter, another order has been passed, and now the date is fixed to 26th June. But in the meanwhile, they have disconnected the railway line to the railway siding and the coal washery. Both have been closed.
And what was the impugned order?
Impugned order is
how are they connected? How are they? Why are you pressing this contempt application? All right.
Well, let it lie over, my lord. After 26th, I will place it.
No, why?
Because, my lord, due to this disconnection of railway siding.
Mr. Was there any direction that the railway siding should not
be disconnected? That was not there. Why they have done it? That railway line is in their land, which is connected to our railway siding and to the coal washery. They now
Petitioner in the present contempt application alleges disobedience of an interim order dated 13/6/2017, whereby the operation of 13/6/2017 passed in WPC number 11425 of 2017, whereby the impugned letter dated 23/2017 passed for evacuation of the structure over the leased land was directed to be stayed till next listing of the case. Stop. The matter was taken up again on 8/1/2024. Said writ petition was taken up again on 8/1/2024, whereby this court observed that the said interim order shall continue in the meanwhile. Stop. Continue till 13/6/2017.
last one was in 25 April.
Till 19/2/2024. Stop. Next, learned counsel appearing on behalf of the petitioner has not been able to point out that the direction for evacuation of structures over the lease land has been implemented by the contenders in defiance of the interim orders passed by this court. First off, the learned counsel for the petitioner, however, has submitted that the railway siding has been shifted.
Not shifted. Railway siding is there, but disconnection, railway line has been disconnected.
But submits that the railway line going to the railway siding
And as well as to the washery,
and as well as to the
coal washery.
coal washery has been shifted. Has been disconnected.
Disconnected.
Has been disconnected. First off, there was no such direction by way of interim order not to disconnect the, what is it? Railway line. The railway line to the railway siding. First off, in our considered view, no disobedience of this court's order is made out. This application is accordingly dismissed.
Item number 25. Item 25.
Yes.
Bank. Against bank, somebody else.
There is no representation on behalf of the parties. This contempt petition is dismissed for default.
Item 26.
Please, Your Lordship. Non-compliance of the order dated 12/1/2023 as well as the 8/9/2023, my lord. This is the second content, my lord. This honorable court directed OP number 2 to dispose of the representation within 1 month. But they have not complied, my lord. Subsequently, I have filed.
By the order dated 6th of April 2023, the order has already been complied with, but I'm giving the copy of the order now.
Happy?
Your Lordship dispose.
Complied with. Liberty to question. That has been, the
Representation has been disposed of by rigid order.
dismissed or what?
No, it's the consideration of your dad made a representation for enhancement of compensation amount in the land acquisition. He has passed an order, detailed order. So that is they are agreed.
It is stated by learned AGA that in compliance of this court's order, violation of which has been released in the present contempt application, comma, a reasoned order has been passed by the competent authority on
6/4/2023.
On 26/4/2023.
My lord.
So, in such view of the matter, comma, this contempt application stands dropped. Contempt proceeding stands dropped. Yes.
Item number 27.
27 also, Lord, it has been complied with that was the order, but nobody is there.
Compliant with. You are appearing.
No, my lordship, I'm for 28.
It is stated by learned AGA that the order of this court violation of which has been released in the present contempt application has been complied with. Contempt proceeding stands dropped accordingly. Yes.
Item 28.
May I please, your lordship? My lordship, I'm on behalf of Mr. T.K. Sao. My lordship,
What?
this is a
Yes.
My lordship, this is a contempt petition arising out of a non-compliance of the judgment dated 2/1/2023.
Yes.
My lordship, the present petitioner is the legal heir of the original petitioner in the.
Oh, what was the order?
My lordship, the order in Annexure 1, page number 6. My lordship, direction was granted to, direction was given to the contemner to carry out the directions within 4 months.
Yes.
All,
Yes, the disposal of it right order dated was 25/8/2023, and he has rejected the claim of the petitioner.
Yes.
I'm giving a copy, my friend, also.
It has been disposed of. And AGA has submitted that a revision order has been passed in compliance of this court's order upon considering the representation of the petitioners.
Yes, sir.
Petitioner or petitioners?
No, petitioner.
Petitioner. Okay, stop. In such view of the matter, no case of deliberate disobedience of this court's order, violation of which has been released in the present contempt application, is made out. The contempt proceeding stands dropped accordingly. Stop. The petitioner shall, however, be at liberty to question the correctness of the impugned decision of the decision. Of the authorities taken pursuant to the order passed by this court before appropriate forum in accordance with law.
Item 29.
Yes, yes, Mr.
You also can look at the order, the order passed by over page 10.
Yes.
Paragraph 3, not it agreed by the council of the party that the issue involved restriction is analogous to the obligation of 29 or 17 batch of cases and which are disposed of. Then therefore involve the detailed reasons stated in the order dated 6/11/2019 passed by this court in obligation number 29 or 2017 or petitioners can dispose of in terms of the said order. And there is nothing else on record to show that the order was communicated to the parties concerned. So I am unable to give a reply to whether the order has been completed or not, because there is no, he is now also not stated anywhere that order was intimated to the party.
All right, Dismissal 44. One appears.
Item 30.
He has been complied with, because I have got the compliance of the documents also.
One appears on behalf of the petitioner. It has been stated by learned AGA that this court's order, violation of which has been alleged in the present contempt application, has been complied with. Thus, the contempt proceeding stands dropped accordingly.
Item number 31.
31, I may be pleased, Lord. Lordship, this contempt application has been filed for deliberate and violation of the order dated 7 December 2023.
Where is that?
I have quoted the order at from page 3. The relevant portion is at page 4. Point number 5. In view of the aforementioned order, Mr. So-and-so, learned counsel appearing for on behalf of so-and-so, learned counsel for the opposite party management, contended that they want to settle the matter for all times to come by awarding 25,000 along with interest at the rate of 9% per annum in favor of Workman, to which the learned counsel appearing for the Workman has raised no objection. Point 6, my lord. So far as reinstatement is concerned, Mr. So-and-so appearing on behalf of so-and-so, learned counsel for the Workman, contended that the similar situated persons who approached the tribunal have been extended with benefits. He also produced a copy of order passed by the authority pursuant to the order
Who is
passed
for
by.
the other side?
No one is appearing. Lordship may issue notice. Executive Municipality, Kendrapada Municipality.
Are you sure the order has not been complied with?
Yes, Lordship, I have filed. I could not file the letter on correspondence. I have the correspondence. If Lordship will permit me, I may file this. Order has not been complied till yet.
Issue notice.
I'm grateful.
Requisites 1 week. After 8 weeks.
Orders item 32.
May it please your lordship. I'm appearing on behalf of senior advocate Mr. J.K. Rath. Lordship, I pray for an
You
adjournment.
cannot appear on behalf of senior advocate,
Please my
any
ignorance.
senior advocate.
Please my ignorance. D.N. Rath, lordship. D.N. Rath.
You cannot appear on behalf of senior advocate. Senior advocate appears on your behalf.
Please my ignorance, lordship.
Yes.
D.N. Rath.
Yes.
Kindly take up Monday, man. Kindly take up if it's Monday, man.
All right. When do you want?
Monday, man.
Monday. This is about what?
The CMAPL, man. Restoration and
Restoration. Why?
man, since 2022, they have filed the restoration petition and it was in defect, my lord. So the opposite party is in debt bed. So considering that, my lord has directed to orally directed.
He was supposed to pay some amount.
Yes, my lord.
Indeed,
That was agreed
That's
between the parties.
Yes, that's why he seeks time.
It's the reason we seek time within Monday.
So
The
once you
amount will
pay
be
the money, then only it
All
will be restored. And
indeed
All right. Monday.
grateful.
I
Lord.
have jointly requested on behalf of this matter on Monday.
Item 33.
May I please? Lordship has issued notice on the question of limitation.
Yes.
Page 17 is the impugn order, my lord.
So limitation, I think, let that judgment come.
In this case, my
Let that judgment come
yes, my
First.
and what has happened in this?
after vacation. We will take up your matter after vacation.
Yes, my
In the
lord.
meanwhile, let the
This matter, my lord, in number of cases that your lordship job contract employee, my lord has also passed one judgment. In that job contract employees, as per rule, they are entitled to minimum pension. That job contract period will count it if the shortfall up to get the qualifying
because
period.
of your rules, that is nothing to do with the judgment.
that I am saying why I am submitting, well, number of cases has been dismissed on the ground of limitation, that we have approached the Honorable Apex Court. In those cases, stay has been granted. So that I am praying it can be deferred for some time after disposal of those cases. It can be if that I am submitting
all right. After
because I cannot place your
Narsu-
merit to your
Narsu
lordship has
Pradhan.
not condoned.
Narsu Pradhan.
No, this is Nityananda Vishwa case. Your lordship, my lord's judgment is there. In one case, my lord's judgment is there.
But in writ appeal, I was party against my.
Only on the ground of your lordship dismissed a number of cases on the ground of limitations. That I am submitting. Those cases are before the Honorable Apex Court, and Honorable Apex Court has granted a stay. So it can come after vacation.
July. Third week.
Item 34. Item number 34.
Yes.
Merit, the original application which was transferred from the Odisha Dismissal Tribunal to the Honorable Court for adjudication, the impugn order was passed. There is a delay in filing the writ appeal, 129 days. Merit, to my predicament, the order was neither uploaded nor supplied to me. That's why 129 days delay. State government is the opposite party. State government is the opposite party. The retired person. And the original challenge.
So there is delay of 120 days.
129, according to me, 120. The registry points out 129.
Yes, your fault.
My lords, I am for the state.
So should we dismiss?
My lords, on the delay is beyond the permissible. I mean, the permissible in the statute. Of course, my lords has the power to condone it.
No, what is your stand?
My lords, as your lordship wishes. Whatever
You
lordship wishes.
vehemently oppose, but
No, not at all opposed, my lords. I'm only as your lordship pleases.
I'll lend counsel for the parties. there is delay of 129 days in referring the present appeal by the appellant. Stop. For the reasons stated in the present application, delay stands condoned. This application is allowed. Yes, press matter.
Item 35, another repeated matter.
My lord, item 35, your lordship was hearing on the question of condonation of delay, 220 days, my lord.
My lord, item 35, my lord, on behalf of Mr. Mahapatra, may be taken up any other date, my lord. He has to rush to his house, my lord, due to his mother's illness, my lord.
I have been waiting for long period. You should have informed us.
You should have informed them.
And again, they're seeking time, my lord.
My lord, any date, my lord, tomorrow maybe.
No, not tomorrow.
He was there, my lord, waiting for the case, my lord, because no other case was there. So for this case, my lord, he was waiting, but due to his mother's illness, my lord, he has to.
Coming Monday, my lord, at 2 p.m. Let it.
So it will come, say, in first week of after reopening.
My lord, only delay what is concerned.
What can I do, my lord? They're taking time every time. As your lordship will please.
In fact, we are going to deliver a judgment on.
Yes, my lord.
You
That's
must
right.
be knowing that. So let it come after
All right, man.
opening first week of reopening.
Item number 36.
My lord, can I pray, my lord?
Yes,
My
please.
lord, can it be at 2 p.m., my lord,
2
on
p.m.
that?
All right. All right.
Grateful, my lord.
At junior counsel's request.
Grateful, my lord.
Yes.
Item number 36.
36, there was a delay of 68 days. Notice was issued. Mr. Das has entered appearance, but is not here.
68.
Maybe he's in some other court. He was here.
Condoned.
Obliged.
Heard both sides.
Item 37.
In this case, notice has been issued on the question of limitation on 16/11/2023. But noting said that, noting undelivered notice returned from the sole respondent with postal endorsement, no such person in the address.
Take first steps.
Are you appealing? Let's say I have an instruction to appear in this case.
Appear.
Then here by only 30.
You can serve copy. He is appearing.
As the counsel before the honorable single judge, I have instruction to appear in this case. Narasimha, kindly direct to file the appeal memo. Copy of the appeal memo.
Give him appeal now.
Yes, I will give.
And what is the delay?
44 days.
39 days.
39 days.
We can condone.
Yes, please.
Third, Mr. So-and-so. Okay. And what is your name?
Rudra Narayan Parija.
Mr. Rudra Narayan Parija for
the sole opposite party, sole respondent.
Sole opposite party who was being represented by him in the writ proceeding. Full stop. Considering the explanation put forth in present application, delay of
39 days.
39 days in filing the present appeal stands condoned. This application is allowed.
Item number 39.
What is there in first hand?
Help.
Delay. How much?
322 days.
This is a rehabilitation matter, my lordship can dispose of, but no one is appearing.
No. WA 194.
No, sir.
This is not rehabilitation.
Sorry, madam.
This is same Pradhan case.
Yes, ma'am. That's
The other one.
Yes, ma'am.
Nityananda Biswal.
This case, I have also instruction to appear for the sole opposite bar, but this is the case there is few days of delay, I have to file the objection.
Give him copy.
Yes, I am giving in course of the day.
Notice on behalf of the respondent number one, the sole respondent. Sole respondent.
Yes, ma'am, sole respondent.
Sole respondent. Also, he seeks time to file an objection to the application seeking condonation of delay. Also, as requested, this matter on after vacation, 3rd week.
Copy of the IO.
He will do that.
In course of the day, I will serve.
Item 40.
4 days delay.
4 days.
4 days.
You are for?
I am for appealment.
4 days delay. Condone. Who is for the other side?
State. State is the option.
Yes. Yes.
It's a very small
It
matter. It
does
can be hard
Yes.
right now also.
My lord, can you take up after vacation?
Yes. I don't know. Item 14. 40.
This matter was 40.
Next. We have allowed.
Item 41.
In item 41, there is 909 days delay. Apart from that, my learned friend has served a affidavit in course of the day that he has relied upon 2 judgments that he has been acquitted in that criminal case, and also I will take instruction, the lordship may call this matter tomorrow, because if he has been
Monday.
if he has been acquitted in that case, this will not be precedent.
AGA this matter on Monday.
Day after tomorrow, I can also take instruction from
All
the
right, on Wednesday.
well.
Item 42.
42 rehabilitation matter, my lord. Notice delay on notice and delay mechanism.
How much?
Delay is 179 days.
That's it.
My lord, since my friend is here, he is appearing.
I am appearing for the, I have already entered application there.
Similar order before. Yes.
Obliged.
One more, may I request my lords, in the judgment itself, which they have challenged my lords. There, my lords, one judgment that has been referred to by the Honorable Single Judge, that is the Secretary to Government, Department of Education, in the para 10, my lords, that may be referred to.
This is my lord's. Bindu Sagar.
No, Vimapa judgment. Para 10 mailers of the impugned judgment in the writ appeal, para 10 mailers. There mailers, the Honorable Supreme Court mailers, they have categorically stated that why the date of death is to be the deciding factor.
This
that
is my
they have
sword.
interpreted mailers. That they have interpreted.
All right, you have got the.
Yes. Okay.
Item 43.
I've given a copy to my now friend.
Comparative.
Receive this copy, alerts. 3 contempts.
All 3 cases.
All 3 cases.
Item 44.
It's an item of 44. My Friend has filed. Friend has filed an affidavit, IA, my lords, stating there in the last occasion it was not there. Now its copy is also received by me, and now it's, I think, on record, your lordships. So I want to respond because she has claimed that juniors to the respondent are still continuing service, whereas she has not been favored with. So, lordship may call it after the holidays. I will file my reply to that IA, my lords.
As requested on behalf of the petitioner, is this matter on? After it's
Item 45.
Fixing a date?
yes, you will get a date.
Item number 45.
45, there are two matters. In fact, the virus of a Government Land Settlement Act, that a particular provision has been challenged. And the two appeal, in one appeal, in one petition, I am appearing in the first case. The second one, Mr.
Second sub-item, I'm appearing on behalf of my learned senior, Mr. S.P. Mishra.
You cannot appear on behalf of senior counsel.
You can engage.
Senior counsel appears on your behalf. Alright, because you engage them.
Well,
They cannot engage you. No, they may, but yes. Yes, please.
Your
Yes,
Lordship may fix it after vacation. In the meanwhile, file the.
seek his consent.
If my learned senior agrees to.
In fact, he had talked to me. There was a counter which was filed just 2 weeks before, because during the course of hearing, they wanted that they will file a counter in this case. They have filed the counter. Copy has not been served.
No, I have given it, subsequently I gave a copy, but it a belated stage.
Yeah.
I had given the copy to my learned senior first. Thereafter, subsequently, I have given a Xerox copy. I have given a Xerox copy to my senior, Mr. Mishra, also. So, lordship can take it out after the holidays. I don't have an objection. Also.
Yes, Mr.
One counter I have adopted in all 3 cases.
On. As jointly requested, these matters on. 8 July.
Your Lordship, interim orders may be continued.
Interim order in wise. All that
It's-
continue.
Item number 46.
I'll go to that side.
Yes.
This matter, in similar matter, your lordship has heard and order is reserved in that case. That is W number 862 of.
What is that matter about?
That is the regarding that Hindi teacher matter, that educational qualification. And the lordship has.
All right, it will come.
Let it come.
After vacation.
862.
After vacation.
Can it be taken up before vacation?
Yeah, but judgment. After
Judgment has not been read.
The 2014
Yes.
advertisement.
That advertisement, whether they.
Sir, Mr. Khuntia, 2014 advertisement, many other cases, Mr. Rautray was arguing before the tribunal allowed.
Yes.
This case was also filed during that time. It could not be tagged up.
Yes.
Yes, yes.
Am I correct?
Yes. And some of the single judge matters,
That
clearly remember, yes.
That has carried to this court.
Division bench, yes, but that was dismissed on the ground of limitation, of course.
This court.
Yes. Writ appeal was filed by the
Was
state.
it carried to Supreme Court?
Yes.
Supreme Court also
Supreme Court also upheld.
SLP dismissed. But there is no merger.
No.
Even
You
writ
cannot
appeal also
quote the extent of merger. No.
in
SLP has been
writ petition
dismissed.
also it is not merger.
Yes. How many vacancies? But still there are 350 number of vacancies are still there in the teachers. And these people, they are all trained. But now subsequently they have trained. And the only question for consideration that note that within this period of
Untrained.
yes, they can acquire the training. That is the only question. And my learned friend says, and in case of some other candidate, they have implemented that. That I have given it specifically.
The findings is there.
That is also a finding of the single. My learned friend Jack said that there is another judgment which has been not, I don't know that. But
860
my learned friend was appearing, he was saying with Mr. Samir Das, that was the case.
Yes, Mr. Samir.
Baptisa who case was.
Yes, I remember
cited.
yours with that. I will. Yes.
I was.
I verify
I
whether
was
that is
party
exactly.
to contempt. There.
Yes, yes.
Justice Singh.
That matter is different.
That is
No,
different.
That matter is different. That is what I have to see. That was
Oh, that is
that's
different.
That is different.
That is the opponent's case.
The openness in a case
That is there.
that's a different. My number of cases there regarding that 2014. One matter you also can get it from the
Same advertisement.
same advertisement
Same
relating
advertisement.
to different subjects.
That was for equivalence.
That was for equivalence. That is contempt matter you also was hearing along
That
with
was
justice.
Equivalence.
Yes, ma'am. That is equivalence. That has been
Sastri was.
yes, ma'am. That has been implemented and he has got that.
That is untrained, qualified in MA
itself.
That is equivalent to.
Whether it will be equivalent or not.
Yes,
So your lordship is to keep fixing after the judgment.
after vacation.
That judgment.
After vacation, and the meanwhile.
My lord friend.
Item 47.
In 47 also same prayer, my lord, because your lordship has heard that matter.
Item 747 regarding.
Regarding that laboratory technician having not qualified, that your lordship heard that matter WS 687 of 2022. That order is also reserved.
Reserve and return note. After vacation. Return
Yes.
note also. I
I have also submitted it.
But in this case, all these cases about 300. In all these cases, my lord, in that case, the limitation was not there. That is why your lordship segregated. All right. So let that judgment come, then we will see whether.
Before making submission, they are not verifying records. Your lordship, for a moment, your lordship may see the first case. Only 10 days delay, 30 days delay. He's saying that.
We will see.
Yes, my
Some of my cases more than 700 days.
if that principle
Right,
you
Mr.
decide that-
Counsel, we will see. We are not allowing their appeal.
May I pray another, there was a common judgment and we have, may I pray that we may assist in hearing because of the.
That hearing is concluded.
What happened, the matters, our matters were segregated on the point of limitation. But we could not
So
assist
we should assist, you should assist when your matter is taken up after that judgment.
judgment. There.
So then no hearing can be concluded. So if a case is decided, then the other side may say that I was not heard because.
May I clarify my lord, that's before the honorable single judge, when that impugned judgment which was your lordship kept for judgment hearing, that was it is where analogous hearing was made clubbing 4-5 cases, and the analogous hearing was made before the honorable single judge. But before this, your lordship on the point of limitation segregated those clubbing matters also the writ appeal filed. Only one matter was taken up for the hearing, and that was kept. So my friend is saying that they are also party to that the judgment in analogous hearing. So they have.
Yes, we will devise method.
Item 48.
Yes.
May please. Well, input order is at phase 10.
Yes.
May I read my relevant for page 12, paragraph 5. pursuant to the notice issued, the opposite parties have filed their counter affidavit contending that no workman junior to the petition has been given re-engagement so far, and that the plea that DLR working other junior to have been re-engaged not relevant nor substantial.
So you are just required to reconsider.
Yes, ma'am. What has happened in this case? LRC was directed to reconsider. Accordingly, we reconsidered and rejected his case. He filed a contempt annexing that order that in that contempt proceeding, notice was issued to comply this order.
So
then we have no option than to challenge this order because
why are you?
We reconsidered, my lord, as per the observation. And we reconsidered it because no junior to him in that division is regularized. Accordingly, we rejected his case. And that was also ground we have taken. After rejection, annexing that rejection order, he filed a contempt. And Honorable Single Judge issued notice to comply this order. Now, what remains for our...
How can we suggest what stand you should take in the contempt proceeding?
We have taken one, with due respect, my lord, once we recon in compliance to that, my lord.
So you reconsider, then that contempt petition is pending.
Yes, my lord. That contempt petition was disposed of. Contempt petition was disposed of with a direction to comply this order.
So you have complied with this order?
Yes, we have complied with this order.
Then
after compliance of the order, annexing that document, that rejection order, he filed a contempt petition.
Second.
First contempt. Annexing that after compliance of the what did your lordship in that order?
See, Mr.
Yes, ma'am. Your lordship was directed to reconsider his case. Accordingly, we reconsider his case.
See, what is happening in the contempt proceeding will not decide the fate of this appeal.
No, my lord. Why you have filed that? I am explaining, my lord. He filed that contempt annexing that rejection order.
Let him do.
And no, my lord, Honorable Court disposed of that contempt petition, directing to comply this order.
So you have complied with it.
We have complied with it.
Again say that you have been complied.
Again, yes, that's true. Otherwise, because we have complied, then that's why this petition.
The petitioner.
My lord, may I please, my lord? My lord, during pendency of that contempt petition, they revoked that order. That what my lord senior is submitting that they rejected my prayer, my lord. During pendency of that contempt petition, they revoked that order. My lord, the contempt on 22/4/2022, there was a direction to comply the order dated 16/11/2022, the original order. Thereafter, they rejected. During pendency, the compliance order was that they rejected my plea. My lord, thereafter, on 29/7/2022, there was an order to comply.
Why are we discussing contempt proceeding here?
My lord?
Why are we discussing contempt matter here? Before us, there is an order which is under challenge. Just see whether the order should be interfered with or not. The state of Odisha has preferred present intra-court appeal, putting to challenge an order dated 6/11/2021, passed by a learned single judge of this court, WPC, AC number 2666 of 2015. Stop. From the impugned order, we notice that the learned single judge has taken into account the fact that the respondent was admittedly senior to 35 employees.
Yes,
Senior.
ma'am. Yes, ma'am.
Our case is not senior. He is not senior in that division. That is our case.
35 persons are not senior.
Yes, ma'am, of that division. A specific case is that, and it is the admitted position in the counter and regender. In that division, no junior is regularized.
35 are senior
of other division.
They are saying that they belong to other division, not to my division. But seniority is fixed by one EIS, my lord, engineer in chief.
Inter-se seniority is being decided.
So who decided?
Engineer in chief, my lord. So 3 divisions were there. I am one among them. So other divisions, they say seniors, the juniors have been appointed. They are segregating that my petitioner is not belong to that division who have been selected regularized.
So how do you say that there is common?
Yes. Common, my lord.
How do you say?
Because my lord, in their counter, in the order my judgment, your lordship, paragraph 8, your lordship kindly have a glance. Para 8, page 13.
Yes.
Having heard learned counsel for the parties and after going through the records, this court finds that the petitioner was engaged as a DLR NMR under the opposite party number 3. As he was disengaged, he filed WPC number 23682 of 2014 seeking re-engagement, and this court, by the order dated 23/12/2014, permitted the petitioner to file representation before the authority concerned for considering his
How do you
given.
say that there was combined seniority of all the 3 divisions?
Lordship, after 2 lines that has been discussed. But such representation was rejected by opposite party number 2 by the annex rate dated 22/1/2015, which has been impugned in this application. But fact remains, if some of the juniors to the petitioner have been regularized and the engineer in chief has recommended the case of the petitioner for absorption.
That is not the question. The question is, who are the persons in this list who were junior to you and who were re-engaged? Where is that list?
That list, my lord, in the counter they have, my lord, also admitted, the state has admitted that the 35s are the juniors, but they do not belong.
Their case is,
my lord,
that seniority is to be decided division wise. Your case is that there is combined seniority for all the 3 divisions.
My lord.
Where is that? How?
My lord.
How that decision is correct?
Your lordship, that is, in that case, and a rejoinder was filed, my lord, in 2766 of 2015. Your lordship,
in the agenda, it is his stand junior to other division.
And what was the reason for rejection?
That juniors of his, may I draw my lord's notice only to paragraph 5 of my count.